Item number 1, CRA 130D of 2000.
The appeal is dismissed. The bail bonds of the appellants are cancelled. And they are asked to surrender by 1st August.
Item number 2, JCRLA 3 of 2012.
The appeal is dismissed.
Item number 3, CRLA 96 of 2013.
The appeal is dismissed. What's the adjournment for?
No, adjournment was due to personal reasons. But I have to go back.
All right.
I'm sorry, Milord.
No problem.
Last item, Milord, item number 25.
All right. Who's for the other side?
Milord, Mr. Chimanka is there. I've informed him.
Oh, at the request of Mr. Kara. List on 16th November. All right.
Greatly obliged.
All right.
Maybe, pardon your lordship, could
Yes,
be
yes.
present little late, my lord.
No problem.
Extremely sorry, man.
Okay.
That item 3 for judgment was there.
Oh, I see. I see. All right.
Special weekly list, item number 4.
Well, item 4, one of the major mistakes that copy not solved. I've already solved.
All right.
But the issue is, can it come to page 84? The issue before the learned tribunal, Civitas Tribunal. At internal page 3 and running page 84.
Yes. With the transportation
Whether
charges.
the transportation charge collected by the appellant dealer from the customers is includable in the sale price, and whether the appellant dealer is entitled to deduction.
Same thing.
And in my case, they said that you have not charged separately. It is already settled. The law is originally by the Honorable Supreme Court.
You have to show it separately in your invoice.
My lord?
You have to show it separately in your invoice.
Yes, yes. How I have separately charged, I have filed the documents. Kindly come to my lord. The document starts at
57.
Page 57, my lord.
Yes.
Some sample copies I filed. How I am charging? This is the of the year 1991-92 assessment year.
So
But
second
the-
paragraph. In the second paragraph, you say I've charged 1680.
Madam, can you come to page 57? I filed some documents.
No, no,
that
I
was-
know. Second paragraph in 57, you
Madam,
said I have included 1680 on account of transportation charge.
Yes, madam.
Ah.
And this is the issued by the dealer, Das Agencies on the top, and it was issued to me saying that this is the cost of the cement and 1,680 is towards the transportation charge. On the top, Das Agencies have issued
Sir,
me.
I am pointing out to you. You are pointing
Yes, madam.
out to
No,
me.
madam.
What is this?
So I'm just
All
correcting
right,
that.
all right.
And the entire he has paid the bill, and my lord kindly straight away turn to page 64. The entire amount was paid to him, and this is with regard to the Das Agencies, page 65. 1,680 I have paid him to the transport agency, and they give us bill and we pay him. All the other transporters in all cases, it is separately we pay.
So you filed this 21 years ago,
Yes, madam.
and till today we have listed it on our own.
Madam.
So you filed this case. You filed this case
Yes, madam.
21 years ago
Madam.
on our own. On the High Court on its own has listed it today.
Madam.
So you have not bothered to get it listed even once in 21 years.
Sorry, madam.
Not for sorry. I'm just see. We've all been lawyers in the bar. If the issue is so urgent, the client is very insistent, then we definitely make mention. Morning, all of you make mention. You yourself make mention, don't you?
Madam.
So what is the impression that for 21 years, this client, it makes no difference to them whether this tax amount is got or not got, makes no difference to them. Only we have punished ourselves by saying, okay, let us take up this 21 year of cases. The client also is not interested, the lawyer is not interested, but somehow we have to get a decision on this.
Sorry, madam.
Not for sorry. Is the client actually serious? See, we don't mind writing one 20-page order. But if nobody is serious about it, why should we write 20 pages for this? I'm seriously asking you, what is the tax effect? How has it adversely affected this client?
But the tax effect is 26 lakhs.
So we obviously either it has a stay here, which the state is happy to forego. Is there a stay?
No.
So why are we wasting our time on this? There is no stay. He's not worried, you're not worried. Why should only the two judges be worried?
In fact, the SCST,
the dealer, this company, and I've seen that it's shown in the MCA website that it's amalgamated in 2017. So whether it's still this company exists or not, my learned senior can be. Because it is showing that it is amalgamated in 2017. So whether this company,
now the
as on date, is
company has been renowned as Dalmia Cement Bharat Limited.
And have you taken any steps for that?
No, my lord.
So why are we wasting our time like this, sir? So we were given judgment and given on paper with no one taking either advantage or.
For a moment, can come to page 56. This assessment was carried in appeal to the SCST. SCST at page 56 at paragraph 6. According to the appeal is partly allowed and partly set aside. The learning assessing officer required to complete reassessment in accordance with the direction given in the appeal order. He has stated so, but after that, what happened? This is the order of the SCST after the assessment order.
So
And
anyway,
again, this
since
order,
nobody is worried about anything, sir, why should we break our heads on this? You see,
the law is well settled, and I have to get the benefit from out of that appeal, out of that.
you see,
law position.
it is 21 years since this revision petition was filed. And in these 21 years, the petition has not even listed once. The last noting is that certain defects were not removed, and that only one of them, namely serving a copy in the standing council, has been cured. Be that as it may, at no point in time has the petitioner moved the court for an early listing of this petition. Neither has the state standing council done so. Full stop. There is no stay of the impugned demand, if any, on the petitioner. Full stop. Council, learned standing council of state informs the court that to the best of his knowledge, it is the petitioner company has possibly got amalgamated with some other company. Full stop. This court has not even been informed of the change. Full stop. No application for even amending the petition as a result thereof has been filed. Paragraph. In the circumstances, the court sees no reason why it should continue to entertain this petition. It is disposed of as such. The questions are left open, if not already answered. Yes.
Special weekly list item 5.
The question of law is at page 96, my lord. There are also the similar things, but I am not troubling the lordship. There are about 9 to 10 questions, but in essence, the question relates to whether the transaction in question is a works contract or it's a contract for supply of materials. So that's in essence the dispute. In fact, the assessing authority has held it to be a works contract that was confirmed in appeal. The tribunal, after laying down various judgments, has set aside the assessment to remanded for fresh assessment.
Let it go, sir. Let the remand be.
Yes,
we say all that the tribunal has done in the present or in the impugned order is to remand the matter to the sales tax officer for a fresh assessment. So there has been no stay of that order by this court in these proceedings. Full stop. It is highly unlikely that in the remand proceedings, a fresh order would not have been passed. Full stop. If not already passed, it should be passed within 6 months from today. The court is not inclined to interfere in the circumstances. The question is left open for consideration in some other appropriate case.
Special weekly list item 6.
6, my lord, in the tax involvement is 21,000.
All right. In view of the insubstantial tax amount, court does not leaves the question open and disposes of the petition.
Special weekly list item 7.
None appears to is not possible.
Special weekly list item 8.
Similar tax involvement is 17,000.
All right. In view of the insubstantial tax amount. Right.
Special weekly list item 9.
None appears to is not possible.
Special weekly list item 10.
Similar it's 6,000.
Right. Insubstantial tax amount.
Special weekly list item 11.
Item 11, my lord, I'm handicapped. My file is missing.
All right. Counsel to state states the file is missing. Dismissed for non-prosecution with liberty to revive the petition as and when their file is located.
Special weekly list item 12.
Well, my lord, it's 2,335.
All right. Insubstantial tax amount.
Special weekly list item 13.
My place. Well, my lord, the question of law is at page 3, my lord.
Transactions did not affect levy of tax. Only one question has been asked. We've asked a tribunal to state the case. And tribunal has not stated the case. Statement of case not filed. Way back, more than 30 years ago, nearly 30 years ago, on 2nd December 1992, this court had asked the tribunal to state a question to this court for its opinion. Stop till date. The statement of the case has not been received. So clearly the state has not followed up on the matter. So in the circumstances, the revision petition is disposed of.
Special weekly list item 14.
None appears dismissal of prosecution.
Special weekly list item 15.
None appears dismissal of prosecution.
Special weekly list item 16.
Item 16, my lords, the conducting counsel is actually ill. My lords, may kindly keep it to.
No. Let's tell us what the matter is about.
My lords,
Kindly tell us what the case is about.
my lords, we have come against the order of the cancellation of our caste certificate. My lords, may kindly send it to the committee then.
Or
Decide on the merits.
the petitioner challenges an order dated 21st November 2005 passed by the
16.
Tahsildar Banki. Under Rule 7 of the Orissa Miscellaneous Certificate Rules 1984, cancelling the caste certificate issue in favor of the petitioner. Full stop. Counsel, the petitioner states that the matter may be referred to the committee constituted by the state for this purpose for an appropriate decision in accordance with law. This is not objected to by counsel of the state. The petitioner is permitted to file a proper application for being placed before the committee concerned, not later than 16th August 2022. And if so filed, said committee will, after hearing the petitioner, pass an appropriate order within a period of 4 months thereafter. Till such time, the interim order passed by this court on 27th February 2006 will continue. The court clarifies it is not expressed anywhere in the matter. The petition is disposed of.
Special weekly list item
I'm
17.
greatly obliged.
None appears dismissal or prosecution.
Special weekly list item 18.
For the opinion number 3 also.
I am for the opposite part number 1 and 2.
None appears dismissal or prosecution.
Special weekly list item 19.
My lord, here this writ appeal, my lord, it was another matter was listed on connected matter, that is 222 of 2012. Your lordship on 13/7/22 has directed this matter to be listed with that on 28th of September.
All right, list on 28th September.
20th of September.
28. 28 September.
Along with WL number 222 of 2012.
List along with WA 222 of 2012 on 28
My
September.
lord, they have filed a counter in that case and this case also. Let them serve me a copy of that.
Yes, Mr. Manthi.
Yes. 222 of
222 of 2012.
Special weekly list item 20.
Please, my lords. My lords, item 20, identical matter your lordship took up on 27/6/2022. Condoning the delay, but your lordship was pleased to pass an order that writ appeal is dismissed. Question of law is kept open.
Same order.
This is the order. Your
All
lordship.
right. Same order. All right.
So 21 and 22 also identical matter.
All right. 20, 21, 22. All right.
And 22, I have filed my appearance from whom my name has not come. Keshikar. 22, my name.
All right. 23, 24. All. Right. Up to 24. Same order.
In item 20, my lord, mine, that order doesn't carry my name. It should
You
be
can put this in. All right.
Special weekly list item 25.
Your Lordship, I beg your pardon. Your Lordship, I'm appearing in the item number 18. So can you please put the presence, as we have received no instructions from the client.
All right. Counsel petitioner says no instructions dismissed.
Greatly obliged.
Special weekly list item 25.
25, no instruction.
No instruction, dismissed.
Special weekly list item 26.
No instruction, my lord. No
No
instruction.
instruction, dismissed.
Special weekly list item 27.
27, my lord. I am in BC, permitted to withdraw.
Counsel the petitioner to withdraw this. Dismissed.
Still exist, my lord.
Special weekly list item 28.
Correction still exist, my lord. With the liberty to.
No, sir. This is only writ appeal.
Special weekly list item 28.
None appears.
Special weekly list item 29.
None appears. This is not. Both.
Special weekly list item 30.
In item 30, I'm appearing through VC, my lord. No, in this case, no instructions.
All right.
And even item 31 not pressed.
All right. 31 is also not pressed. 30.
List or notice, no?
None appears. This is not. Go to 32.
30, 31 both not pressed, my lord.
Okay. 30 and 31 not pressed. Go to 32.
Special weekly list item 32.
32, my lord, pass over, my lord. Pass over.
All right.
Special weekly list item 33.
33, my lord. I pray day after tomorrow because I got the file. My clerk was ill. Just now I got the file.
We'll read it with you, sir.
My lord.
We will read it with you. Let's see what it is.
My lord, kindly see. That is the sole point. Without notice, the delay has been condoned. That is the sole point.
What is the big deal in that, sir?
My lord.
There's nothing in that.
Page 5, paragraph 10 of my affirmation.
Yes.
That the opposite partner has filed an application.
There is no stay, sir.
My lord.
There is no stay here.
No stay here.
Then that will be over by now. You say the petitioner has come in a questioning an order dated.
Well, that is not over, my lord. That is still in.
It's okay. Let it be, sir. Order dated 6th March 2012. Passed by the authority under the Minimum Wages Act 1948, condoning the delay in the claimant filing the application. Having heard learned counsel of the parties, the court is not satisfied that any error has been committed by the authority warranting interference. The petition is accordingly dismissed.
Special weekly list item 34.
I pray, my lord. And I pray one thing, my lord. This is an expiry order. I'll file petition before the authority.
Not after so many years, sir. You go and participate. That's more than enough.
My lord, but I observed that.
Who can stop you from participating?
My lord?
Who can stop you from participating?
If my lord will not observe, only I will participate in the hearing. I will file expiry hearing. That what's only help me.
Counsel, the petitioner states that he will file an appropriate application before the authority to participate in the proceedings. All right.
That will consider liberal.
Special weekly list item 34.
May it please your lordship. And this is a matter pertaining to the compensation and rehabilitation and resettlement policy. And this is the second round of litigation of the petitioner before this honorable court, my lord. And earlier, the petitioner had filed a writ petition for consideration of his application to be declared as a displaced person. Pursuant to the order in that writ application, the petitioner was granted the benefits, and also he was declared a displaced person. But after being declared as a displaced person, either he has to be given an employment, or in lieu of employment, he has to be given some amount of compensation. Though accordingly, the petitioner demanded that a compensation amount of 5,52,000 that is due under the 2006 resettlement and rehabilitation policy is to be paid to him. However, after granting the displacement card, he was given 2,49,000 as compensation. Challenging that, the petitioner, before the state has also filed its counter affidavit on the last date of this of the hearing of this case. My lord, the then Joint Secretary of Revenue was present, and he was directed to obtain instructions regarding the specific notification under which 2,49,000 has been paid. Because in the counter affidavit, the state has averred that we are entitled to be paid compensation on 2005 guidelines, 2005 resettlement rehabilitation guidelines. However, the state guidelines that has been annexed to the counter affidavit, it came in the it was published in the Orissa Gazette, my lord, on 18th November 2005. But my lord may kindly have a glance to Annexure 3. Annexure 3 says that we have been granted 2,49,000 by government order number 34510 dated 23/8/2005. So there are contradictory stands regarding this. The joint secretary was present in the court, and the state was also directed to produce that particular order by who is this compensation has been granted. Also, my lord, our claim is that we are entitled to get compensation under 2006 guidelines, because the other benefits like the temporary set, the maintenance amount, that has also been paid under the 2006 guidelines. But when it came to the employment and or in lieu of the employment, the compensation, they are saying that you are entitled to pay under get under 2005 guidelines. So they cannot pick and choose as to whether when they will be when we'll getting the HB assistance. For example, HB they have paid us HB assistance that is under 2006 guidelines. Temporary said assistance that is under 2006 guidelines. But when it comes to the employment and or in lieu of that the compensation, they are saying that we are entitled under 2005 guidelines. Also, in the counter affidavit, the 2005 guidelines that they have referred to is not the order that they have passed under Annexure 3. They are both are contradictory orders. So 2 lakh for also in the 2005 guidelines, there are no provision for 2,49,000. There is provision for 2 lakhs, and under 2006 guidelines, there is provision for 5,52,000. So where from this 2,49,000 came from? Regarding that, the state was directed to produce that particular order.
That order, unfortunately, is not in the file. Millets may give me a week's time. I will get instructions. But Millets, the stand is that 2006 guidelines, because the policy of 2006 is prospective. So as per the 2006 guidelines, the compensation is 5 lakh.
Just read that 12th August 2017 order. You don't have the order, just get the file. The hard copy of the file, which has 12th August 2017 order. Just leave it. Just read it, please. Kindly read it aloud.
This matter is taken up in the High Court level Lok Adalat. Learned counsel for the petitioner submits that the petitioner, being the beneficiary under category 1 of land house, is entitled to get a cash compensation of 5,52,000 in lieu of employment as per Annexure 4. But a meager sum of 2.49 has only been sanctioned in his favor, which he has not accepted. Mr. Naik, Learned's additional standing counsel for the state, referring to para 7 of the counter affidavit, submits that since the petitioner has exercised his option to avail cash compensation in lieu of employment on 26/7/2014, the ADM Kalinganagar intimated Messrs. MISL Kalinganagar to make appointment of cash of 2.49 in lieu of employment to the petitioner. In view of the submission made by the learned counsel for the petitioner, Mr. Naik submits that this matter may be placed before the next Lok Adalat, by which time he will take definite instruction with regard to the amount of cash.
Who's the authority concerned, sir? Secretary Water Resources. Because next hearing, Joint Secretary to the Government and Water Resources Department is present. Which is the concerned department?
Revenue, my lord. Revenue Department.
All right. On 12th August 2017, the following order was passed. Although more than 5 years have elapsed since then, counsel for the state has no instructions. Paragraph. It is seen that after the above order was passed, the matter was listed again on 9th September 2017 before the Lok Adalat. And some more time was sought for instructions. But to no result. Paragraph. In the circumstances, the court directs that the Commissioner cum Secretary Revenue and Disaster Management Department will examine the entire matter in light of the above issue, and after hearing the petitioner on a date to be intimated to the petitioner at least 10 days in advance, pass a reasoned order not later than 1st November 2022 and communicate the order to the petitioner not later than 9th November 2022. If agreed by such order to be open to the petitioner to seek appropriate remedies in accordance with law, the petition is disposed of. The court clarifies it has not expressed any view in the matter.
Special weekly list item 35.
Obliged,
Lordships, with the efflux of time, the matter has become infructuous.
Counsel, the petitioner states the petition has been rendered infructuous.
In fact, it's covered by the anti-tax matter. It's covered by the full Jindal Stance.
I know.
Special weekly list item 36.
My lord, in this case, I have cherished the assessment order. I may be permitted to file.
All right. Counsel, the petitioner seeks leave to withdraw this petition. Ready to file an appeal in accordance with law. If such appeal is filed not later than 22nd August 2022, accompanied by an application for condition of delay, explaining the delay on account of dependency of the present petition, will be considered by the appellate authority in accordance with law. Court clarifies it is not expressed in the matter.
Original land.
If the appeal is accompanied by an application for interim relief and is filed within the time stipulated, then till such time the appellate authority passes an order thereon, the interim order passed with this court on 28 September 2012 will continue. The originals be returned subject to being substituted with an attested photocopy.
Special weekly list item 37.
In item 37, my lords, no instructions.
No instruction, dismissed.
36. Special weekly list item 38.
None appears dismissed.
Special weekly list item 39.
Your my lord, the question of law is at page 10.
No, but you've not, it's a defect not removed.
My lord, the miscase has been filed for dispensing with filing of certified copies. That is the only defect. Certified copy of Annexure 1 and 2 has not been filed. In fact, if your lordship would see, the question of law relates to imposition of penalty under section 107 of the OVAT Act by the assessing authority. The question is whether, when the statute says that it's only the commissioner who can impose the penalty, whether the assessing authority has the power to impose or not. In fact, your lordship would see in the present case, the assessing authority has in fact not levied any penalty whatsoever. If your lordship would see Annexure 1, page 13, that's where the assessment order starts.
Then why are you worried?
My lord?
Then why are you worried?
In fact, your lordship may, because 107 situation has not arisen
There's no need to worry at all about it then. The petitioner points out that no penalty has been levied under section 107 of OVAT Act by the assessment order.
It has only been remanded. It's an open remand.
In that view of the matter, there's no need to interfere with the impugned order of the tribunal, merely remanding the matter. The petition is disposed of.
Special weekly list item 40.
None appears.
Excise matter has become infructuous.
All right.
Special weekly list item 41.
Here, Annexure 3 is under challenge, where engagement of a lawyer has been turned down.
That's settled now.
My lord, in view of the judgment of this honorable court, your lordship may allow the writ petition. Because this honorable court has declared section 36(4) as unconstitutional.
All right. Where is that judgment?
There.
Actually, there are, even though he's supporting my case, there are divergent views of our High Court. I have given that list on the first page itself. But if we go by the Allahabad High Court and Madras High Court, and then Kusum Ingots is followed, then
he's following this court's judgment itself, he says. Orissa Forest Development Corporation versus Minati Behra.
Yes, but that judgment doesn't take note of earlier two judgments.
All right, this is the last judgment. By the judgment dated 13th May 2022, in writ petition civil 20007 of 2013, bracket Orissa Forest Development Corporation Limited versus Minati Behra. Rule. Sorry, section 36 bracket 4.
No, they
No,
have.
where has it been declared ultra
No,
virus?
it has not been declared ultra
Yes,
virus. That's what.
unconstitutional. Unconstitutional.
Has it? No, come to para 9.
Para 9, my lord.
Ah.
In such background, we have no hesitation in coming to a conclusion that the petitioner management cannot take the plea of subsection 4 of section 36 of the Act to challenge the impugned order because as per the judgment of Allahabad High Court in ICI India Limited
So
case.
this court has followed. It has followed Allahabad.
They have followed the ICI case.
But there are two contrary judgments. But
that's okay. He's not even relying on it.
Yes.
Why? You see, this court has, in the above judgment, followed the judgment of the Allahabad High Court in ICI India Limited versus Labour Court, 1992, SEC Online, Allahabad 311, declaring section 36 bracket 4 of the Industrial Disputes Act, right?
My lord.
1947 as unconstitutional. That view of the matter, the impugned order dated 28 August 2012, passed by the Central Government Industrial Tribunal cum Labour Court, Bhubaneswar, in ID case number 6 of 2009, is hereby set aside. The said case will now be listed for the tribunal on 22nd August 2022 for being proceeded with further in accordance with law. Right.
For the information of the court, actually, this matter is now pending before the Supreme Court for a reference to the larger bench, because the earlier view of Paradip Port they want to reconsider.
I see. All right.
Special weekly list item 42.
None appears to dismiss non-prosecution.
Special weekly list item 43.
None appears to dismiss non-prosecution.
Special weekly list item 44.
There's a memo for withdrawing the petition. Dismiss this withdrawn.
Special weekly list item 45.
May I please, your lordships? In this writ petition, my lord, the petitioner has prayed for seeking a direction to the opposite party number 2, land acquisition officer, to refer the dispute under section 30 of the Land Acquisition Act, my lord.
Must have already happened, sir.
Well, what has happened? Well, the LA or land acquisition officer has no jurisdiction to decide the right, title, and interest of the parties, my lord. But under Annex 6, my lord, instead of referring the dispute under Section 30 of the Land Acquisition Act, my lord, he has decided the right, title, and interest of the parties, my lord. And the counter has been filed, my lord. They have taken the plea that there is limitation, my lord. But an application for praying for a reference has no limitation, my lord. I have got one judgment of this honorable court, my lord, under section 30, limitation. My lord.
Can you see page 20 of the counter affidavit?
Yes.
Now, there we have stated that 7 numbers of objections were received, and his application to refer under section 30 has been rejected.
On the ground of limitation, he says.
No, not on the ground of limit, because the original recorded tenant is alive.
I have also made one date chart, my lord. Your lord, there is the date chart, my lord.
Objector serial number 1 is the present petitioner.
They are still alive. It's not limitation. The ground on which it's rejected is they're all alive still.
I am submitting one date chart, my lord. Your lord, may kindly peruse my date chart, my lord, along with the genealogy, my lord. In the second page, there is genealogy, my lord. One Somnath was the original recorded tenant, my lord. He died leaving behind 2 sons, Hrudananda and Madhusudan, my lord. Hrudananda died leaving behind the present petitioner, Annapurna, as is only legal here, my lord. On the other hand, my lord, Madhusudan died leaving behind 1 son, Bhaskar, and he had 3 sons, my lord, Narayan, Pitambar, Umesh, who are the opposite party number 3 to 5, my lord. Behind the back of the petitioner, my lord, they partition the land among themselves, taking the advantage that the petitioner is staying in another district, in another village after her marriage, my lord. Thereafter, she filed the representation, that is petition for a reference under section 30 of the Land Acquisition Act under Annex 4, my lord. I have filed it at Annex 4, your lordships. Kindly peruse Annex 4, my lord. That petition was filed on, my lord, 8/11/2012, my lord. That has been received by the LAO on 8/11/2012, my lord. instead of adjudicating the matter, my lord, behind the back of the petitioner under Annexure 6, my lord, he has passed the order. Whenever an application under Section 30 is filed before the LAO, my lord, it is his duty bound to refer the claim of the petitioner, my lord. But the LAO has not done this in this instant case, my lord.
Yes, Mr. Mudali.
Section 30.
Yes, Section 30. At any time it can be filed, my lord. I have given the judgment of this honorable court, my lord. There is bar under Section 18, my lord. There is no bar under Section 30 of the land acquisition.
Argue, sir.
Section 60, Section 30. Dispute as to apportionment. When the amount of compensation has been settled under Section 11, if any dispute arises as to the apportionment of the same or any part thereof, or as to the persons to whom the same or any part thereof is payable, the collector may. You will also kindly mark the word is used as may, not shall. May refers to a dispute to the decision of the court. So the discretion lies with the land acquisition collector, whether in the
No, is it correctly exercised or not? Then it becomes the question: why have you refused?
He has refused because since the original.
He has not merely refused, sir. He's gone and decided.
No, he has not decided.
Yes, let's turn to Annexure 6.
My lord.
Oh, he's only asked to inquire and submit a report.
Yes, but you also can see the Annexure C/2, page 19. That is the order passed on his petition. Annexure C/2, page 19 of the counter.
No, but what is this being alive has to do with is seeking a reference? Just come to this page 6. That order sheet is at page 5, Annexure 6.
No, I don't have the copy of this.
No, Annexure 6 has been separately filed.
Yes, ma'am. Yes, this is the order. Bottom, your lordship, serial number 1 is the present petitioner. She is one of the objectors among the 7 objectors. Since the recorded tenant, namely Pitambara Naik, son of Bhaskar Naik of Khata number and Narayan Naik, Bhaskar Naik are alive, the question of entertaining the claim of the objectors for payment of land acquisition compensation out of the above building does not arise. Now, had the recorded tenant died, well, they could have claimed for apportionment of the compensation amount.
Your lords may kindly turn to
all the
Annexure.
you can see the RORs I have filed.
Yes, in the RORs also the name of the
B/2 of the counter, your lords, you can see B/2, page 9.
Page 9 also reflects the name of the petitioner, my lord. Page 9. What my learned senior?
Page 9, recorded tenant is Pitambara Naik. That is in vernacular language. Recorded name is Pitambara Naik. Then page to another ROR that is in the name of one Narayan Naik. And all these two recorded tenants are alike.
Your lordship, I am for the awardee, private opposite party, my lord. Award has been passed in my favor. That in OLR case in 2016, my lord, that land was partitioned and allotted and ROR was issued in favor of 3, 4, and 5. But the dispute is relating to acquired property, my lord, only 371. That she has alleged that there half of the share he is claiming. But regarding 370, there is no dispute. But you lordship kindly see one thing, my lord, he has filed amendment petition that this petition for reference under section 30, that annexure 4, that has been rejected on 2/1/2013, but read petition has been filed on 15/1/2013. My lord, prior to filing of read petition, his petition has already been rejected, my lord.
So he's challenging that.
Your lordship. But
subsequently he challenged. That amendment petition has not been allowed probably till date.
It's okay, but this stage, why should we not?
In the counter, we have stated that the entire compensation amount has already been released in favor of the recorded tenants. Page 4, you let's see, page 4, bottom, 9th line from bottom. Line starts with, in the present case, attend the petition has neither challenged the order.
It's already infractuous. So, a reference will be infractuous anyway.
Yes.
But in prayer, my lord, his prayer, lordship prayer person, that annexure 4, the petition that under section 30, that is to be made reference under section 30. But by that time, that has already been disposed of and rejected.
My lord, Petition was filed on, my lord, 8/11/2022, my lord. I have given the date cert, my lord.
Not 22.
Award,
sir.
thereafter award was passed, my lord.
Not 22.
8/12/2012, my lord.
12.
Petition has been filed much prior to passing of the award, my lord.
How can it be, sir? It's all premature. Without an award being passed, how can you make a petition?
Because the petitioner's name was not found in the notice, my lord.
No,
The
no,
notice
you have to wait
issued
for the
by the
award.
person interested, my lord.
So without an award, what is the point in making an application? You say the challenge in the present petition is for the prayer in the present petition is for a direction to the land acquisition officer come Tahsildar, Pada, District Sundargarh, to make a reference to the Civil Judge Senior Division Sundargarh under Section 30 of pursuant to the application filed by the petitioners under Section 30 of the Land Acquisition Act 1894. Paragraph. It appears that the said application was made even before the Land Acquisition Award was passed on 8/12/2012. So be that as it may, the subsequent attempt by the petitioner to challenge also an order passed on 2nd January 2013 by the Land Acquisition Officer, Pada, declining the prayer for making a reference, has not been actually allowed by this court. Paragraph. By the said order dated 2nd January 2013, the petitioner's prayer was rejected on the ground that the original recorded tenants were still alive, and therefore the question of making the reference did not arise. Paragraph. The court is informed today that the compensation amount has already been dispersed to those recorded tenants, and therefore the question of making a reference at this stage into Section 30 of the LA Act does not arise. Paragraph. Leaving it open to the petitioners to seek other appropriate remedies vis-a-vis the compensation amount already disbursed to opposite parties 3, 4, and 5, the petition is disposed of.
Special weekly list item 46.
Please, Your Lordship. Here, Your Lordship, matter relating to shifting of foreign liquor offshore, Your Lordship. Matter 2013, I have no recent instruction, Your Lordship. Dispose of with liberty.
State has no instructions, the petition is dismissed. All right.
Special weekly list item 47.
None appears to sit in offer.
Special weekly list item 48.
Item 48. My lords, there is a noting that opposite party number 6 has filed a counter affidavit. Nothing has been served upon me.
What is it, sir? What's the matter about?
Matter about the writ petition has been challenged. The annexure form lot, the revision or annexure 9 and the revision order. As per annexure 3, the Honorable Apex Court has in the same has directed to reassess the reassessment of the tax. But without reassessing, they have recomputed without giving hearing. So that has been challenged before the commissioner, and it was upheld, and that has been filed in revision. Revision upheld the assessment, the recomputation order, and that order has been challenged in this writ petition. They have filed a counter affidavit. Let a copy may be served upon me.
Counter was filed way back, sir.
No copy has been served.
That's all right, sir. You should have found out where it is. You could have called the council. A very detailed counter, sir.
Malad?
It was filed way back on 16th December 2017.
Let a copy may be given. Malad may take up next week any date.
No, but why adjourn? This is such an old matter, sir. 9-year-old matter. Counter was filed way back in 2017.
Let a copy may be served.
So we're not adjourning these matters like this endlessly, sir. Sorry.
Here there are
What is the stand? What is the stand in the counter?
In fact, it's the fourth journey of this petitioner. On last 3 occasions, the matter is reached to the Honorable Apex Court, and that is how it has been remanded. Now, the impugned order arises out of the remand by the Honorable Apex Court. That you recompute. In fact, there are 3 transactions in question, which the dispute was whether it is to be treated as an interstate sale or intrastate sale. That's the dispute. Lastly, the Honorable Apex Court has said that treat this transaction only as interstate and reassess. So now that as a transaction has been recomputed. So in fact, it has been categorical. The only these 3 transactions out of this one is to be assessed. Now he has been assessed on that.
No, but what is he challenging here? The assessment order?
No, I'm challenging the Annexure 9.
No, which is what, an assessment order, right?
The order passed by the Honorable by the Additional Commissioner Sales Tax in revision 1110 of 11. That is at page 332, Annexure 9.
So now there's a tribunal, correct?
Yes, Mother. Now there is a tribunal, but this revision order has been challenged, and they have basing off on the only point that since Honorable Apex Court has directed for reassessment regarding this valuation which has been the goods which has been sold to Coal India Limited, but without doing assessment, they have recomputed the matter, and overall the recomputation also
order,
they have not.
This order at Annexure 9, 30th January 2012, it's an order in revision.
Yes, ma'am. Yes. In revision.
Yes. And it is, what is it told? Para 12. What is wrong with this order, sir? What is wrong with this order of the Additional Commissioner of Sales Tax?
Only hearing opportunity of hearing would have been given.
No,
there would have been.
You were heard. Your name is shown there.
In the assessment, man.
Sorry?
The assessment, in the assessment.
It's all right. When revision you've been heard at length, sir.
Let a copy of the counter affidavit.
No,
any
no,
date,
there's nothing. Simply
any day, 2-3 days, my lord.
Simply we're not adjourning matters. It's already a 9-year-old matter.
In fact, paragraph 14, page 338, the revisional authority, paragraph 14. The revisional authority has said that you produce all those documents before me, but he has not produced any of the documents. That is recorded in paragraph 14.
Yes.
Page 338.
All right. Prayer in the present petition. No, the challenge in the present petition is to an order dated 24 January 2008. Passed by the Deputy Commissioner of Commercial Taxes, Rourkela 1 Circle. passed by the sales tax officer, Roorkela 1 circle, determining the tax liability of the petitioner under the Central Sales Tax Act after adjustment of the admitted tax paid at the time of filing of return. So the tax determined was payable was rupees 55,34,427. Challenge the petition is also to the subsequent order dated 31st January 2012. Passed by the Deputy Inspector of Sales Tax for Roorkela 1 circle. Dismissing the revision petitions filed by the petitioner. In other words, the Additional Commissioner of Sales Tax, who passed the said order at 30th January 2012, declined to interfere with the orders of recomputation passed by the assessing authority. Paragraph. While directing notice to issue in the present petition on 21st July 2014, no, on 22nd October 2015, this court stayed the operation of the above orders, subject to the petitioners depositing 50% of the demanded amount before the opposite parties in 2 installments on or before 22nd January 2015. This amount has been paid?
There is a stay order in this. Half of the amount has been already paid.
Counsel petitioner confirms that the above order has been complied with. Paragraph. How many questions have you framed, sir? 14 questions. Paragraph. The background facts are that the Roorkela factory of Gulf Oil Corporation was demerged and transferred to the Ideal Explosives Limited, a 100% subsidiary of the erstwhile Gulf Oil Corporation Limited, under a scheme of arrangement sanctioned by an order dated 15 March 2011 of the Andhra Pradesh High Court. The petitioner is stated to be a manufacturer of explosives, detonators, accessories, holding license under the Explosives Act 1884. Paragraph. The petitioner had a manufacturing unit in Orissa and is registered under the Orissa Sales Tax Act 1947, bracket OST Act, bracket, as well as the CST Act. The petitioner states that it sent goods to various branches of the agents in other states, taking into account the market conditions in the respective states. Full stop. The branch public agents which took physical delivery of such goods stored them in their godowns. The petitioner and its agents regularly supplied and sold goods to government undertakings like NMDC, Coal India Limited, bracket CIL bracket. Because of greater bargaining power, the CIL is said to have fixed rates at which explosives, detonators, etc. would be supplied to itself and various subsidiary companies. In turn, the said branch public agents sold the quantity of explosives to the subsidiary companies out of the stock lying with them, open quotation, and collected and remitted the sales tax under the local sales tax acts for the concerned states. Petitioner then claimed exemption on the stock transfer of goods to the branch public agents. By an order dated 15 July 1986 for the year 1982-83, the tribunal remanded the matter to the STO for reassessment in light of the observations made in that order. Paragraph. This reassessment was completed on 29 July 1994, holding the dispatches made by the petitioner to be interstate sales. Then the first appellate authority reversed this finding by an order dated 30 January 1995, holding the dispatches made by the petitioner to consignment agents as stock transfers. By the common order dated 25th October 1996, the tribunal disposed of the second appeal filed by the state of Orissa. Paragraph. The reference made for the years 1977-78 to 83-84 were disposed in SJC numbers 2 to 8 of 1989 were disposed of by an order dated 11 February 1992, and the matter was remanded to the tribunal for a fresh disposal. The tribunal, by its order dated 15th May 1992, modified the second appeal orders to stop the reassessments for the aforementioned years 1977-78 to 83-84 were completed by treating the transactions as interstate sales, and the assessments were confirmed in first appeal. Stop. Again, the SSC went before the tribunal with second appeals. Which were disposed of on 25th October 1996, taking the view that the movement of consignment was way of stock transfer and not interstate sale. Also, accordingly, the petitioner was held entitled to claim deduction under Section 6 Capital A of the CST Act in respect of transactions with CIL. it is pointed out that the Supreme Court, by its judgment dated 16 November 2007, held that the deeming provision should be given its full effect and that the assessment could be reopened only on a small, only in the instances of fraud, misrepresentation, or collusion. Once Form F is accepted, the interstate transfer of goods is deemed to be a stock transfer. The contention of the petitioner once it is declared to be an interstate sale, then the C form should have been accepted. It's also contended that opportunity ought to have been given to the petitioner to produce such C forms. And that in such event, opposite party number 2 has no jurisdiction to deal with an assessment order. As an appellate authority. Paragraph. There is no interim order passed with this court, right? Oh, actually, the two installments, right? As already noticed, an interim order was passed on 22nd October 2014 by this court, staying the impugned orders dated 24 January 2008 and 30th January 2012, subject to petitioners depositing 50% of the demanded amount. Paragraph. A counter affidavit has been filed by the Deputy Commissioner of Commercial Taxes stating that by the order dated 16 November 2007, the Supreme Court had already settled the issue, which stood settled once and for all. It was clear that the petitioner's prayer that the F forms should be accepted as C forms was rejected by the Supreme Court. It is submitted that it is pointed out that the petitioner has been frustrating the above order the last 10 years by coming back to the court 8 times on various issues. Stop. The recomputation order dated 24 January 2008 is passed by the assessing authority only in obedience of the above order dated 16 November 2007. Stop. It separated it bifurcated the turnover of the petition into 2 parts. That is transactions with C forms and those without C forms. Stop. The turnover without C form was taxed at the state rate, and those with C form at the concessional rate under Section 8, Bracket 2 of the CST Act. So these C forms were given by the petitioner itself. Stop. It is pointed out that the petitioner has been unable to collect C forms from various states for transactions from 1977 onwards. And in the meanwhile, the CST regime has got subsumed in the GST regime. Full stop. Once the petitioner's appeal was dismissed by the Supreme Court on 16 November 2007, holding the transactions to be interstate sales and not branch transfer under Section 6 capital A of the CST Act. The consequences had to follow. First paragraph, the counter affidavit sets out in a tabular column in para 9 the basis of recomputation. Paragraph. It is pointed out earlier the 2503 of 2010 had been filed by the petitioner in this court. Sorry, 2503 to 2510 of 2008 had been filed by the petitioner in this court, which was dismissed by this court on 10th April 2008 as withdrawn, leaving all questions open and clarifying that the said dismissal would not prevent the petitioner open quotation, from approaching any other forum in accordance with law. Paragraph. Then an Article 32 petition was filed directly by the petitioner in the Supreme Court, being writ petition civil 515 of 2008. Full stop. Again, this petition was withdrawn by the petitioner. And the Supreme Court passed an order on 17 November 2008, recording the statement that, open quotation, an appropriate petition will be filed before the High Court. Again, unquote, full stop. Paragraph. For the second time, on 7/10/2009, writ petition civil 11866-73 of 2009 were filed in this court. Full stop. These were dismissed on 7th October 2009, referring to the earlier order dated 10th April 2008. And noting, therefore, that, open quotation, nothing remains to be decided in the present petition. Full stop. A review petition was thereafter filed, which was dismissed by this court on 22nd March 2010. A specially petition was filed. Specially petitions were filed at the Supreme Court, which were dismissed by the Supreme Court on 20th August 2010, granting liberty to petitioner to approach the single court's appropriate authorities. Paragraph. Then on 20th September 2010, the SSC filed revision petitions against the recomputation order. Noting all of the above proceedings and therefore upholding the recomputation orders. Paragraph. With this long line of litigation, the court is satisfied that the present attempt by the petitioner to reopen all the proceedings after repeated rounds of litigation failed, should not be permitted, as it is an abuse of the process of court. Full stop. All the issues raised by the petitioner have already been conclusively decided against it by the order of the Supreme Court, and it is therefore not open to this court to reopen these issues time and again. Full stop. It was equally not open to the authorities below to revisit the issues. Stop. All that the impugned orders do is to recompute the tax liability on the basis of the orders of the Supreme Court. Stop. Consequently, this court is not inclined to interfere with either of the impugned orders. Stop. The petition is dismissed. The interim orders vacated. The amount already paid by the petitioner pursuant to the interim order passed with this court will be adjusted by making the further payment of the demanded amounts. Full stop. Right.
Special weekly list item 49.
Sir, I seek to withdraw this writ petition and with the liberty to file a fresh.
Withdraw this petition. Dismisses.
With the liberty to file. Cause of action survives.
No. Dismiss.
Obliged.
Special weekly list item 50.
None appears to dismiss non possible. The interim order is vacated.
Special weekly list item 51.
My lord, in this case, the petitioner is a license holder of a CS of my lord, Country Spirit Liquor, my lord. He has challenged the demand notice for the period when the authority failed to supply the MGQ.
That order, your lordship, is passing in all other cases. Let him approach the excise commission.
Where is that order?
The interim order may continue. That has been stay of operation of the demand.
Where is that order, sir?
That appeal, I have to prefer appeal, but the interim order dated 2/7/2013 will continue.
Counsel, the petitioner seeks leave to withdraw the present petitions with liberty to approach the excise commissioner in accordance with law against the impugned order. Stop. If such petitions are filed not later than 22nd August 2022, accompanied by an application for continuation of delay.
Liberty, my lord. Only liberty will help you. No. You have to file a petition for continuation of
Citing the pendency of the present petitions as the reason for the delay to be considered by the commissioner in accordance with law. The court clarifies it is not expressed in even merits. Paragraph. The interim order passed with this court on 2nd July 2013 in WP Civil 9490 of 2013. And the
There are two
corresponding interim
cases.
order passed by this court on 18 March 2013, the petition 3978 of 2012 will continue till the excise commissioner passes appropriate orders on the applications for interim relief to be respectively filed in both matters by the petitioner, provided the revision petitions are filed within the time indicated. The petitions are disposed of. The the excise commissioner will endeavor to dispose of those petitions within a period of 4 months thereafter. The petitions are disposed of in the above terms.
Special weekly list item 52.
My lord, item 50 I present before this honorable court, my lord. All of a sudden, 50, item 50, my lord. Maybe take item 50.
Yes, please.
Move. I present before this honorable court. All
Kindly proceed, sir.
My lord, 52, my lord.
Kindly, he's in 50.
50, yes.
I've said kindly proceed. Proceed means not proceed out. Proceed with the matter.
My lord, there is a racial discrimination. On 7/4/2012, village Chanudmal of Balangir district, my lord, and the scheduled caste family, my lord, 2 members, the general caste, higher caste, killed by 2 scheduled caste members, and the scheduled caste member injured under section 307 IPC, and the resident dwelling house of the scheduled caste family broken by higher.
This will take some time.
My lord,
Yes, it will take some.
This will take some time to argue this matter. Will you take some time, sir?
Obliged, my lord.
No. Will you? I've asked you a question. Will you take some time to argue this question, to argue the matter?
No, my lord.
No.
Not much time, my lord.
ଆପଣ ଟିକେ ଅଧିକ ସମୟ ନେବେ କି ଆର୍ଗୁମେଣ୍ଟ କରିବା ପାଇଁ?
ସମୟ ଲାଗିବ କି?
ବେଶୀ ସମୟ ଲାଗିବ, my lord.
ବେଶୀ ସମୟ ଲାଗିବ.
ବେଶୀ ସମୟ ଲାଗିବ.
Not much time, my lord.
My lord, what has happened? My lord, what has happened in this case?
କେତେ ସମୟ ନେବେ? 10 minutes, 15 minutes, କେତେ ସମୟ?
5 minutes, my lord.
5 minutes. କହୁଛନ୍ତି ଏଡେ ବଡ ଫାଇଲ ପରା.
Yeah, my lord, this is only the rehabilitation matter, rehabilitate, compensation. The victim family wants pray for compensation.
My lord, we have filed several affidavits. What are the compensation we have already paid to them?
No, my lord. As per rule,
ଆପଣ ଟିକେ ଅଧିକ ସମୟ ନେବେ. 5 ମିନିଟ ସରିବନି.
maybe fixed in next week, my lord. Fixed date, my lord.
Special weekly list item 52.
Oh, let's go.
Please, my lord, relating to appointment under rehabilitation resettlement scheme policy 2006, the land of the petitioner has been acquired by the Vedanta, and in spite of the administrative order decision, my lord, he has not been appointed. The question, my lord, when the land of the petitioner, he was a project affected person, PAP. So the people of the village agitated the matter not to take their land because they are losing the livelihood. In this regard, my lord, under Annexure 2, the Vedanta company gave and wrote a letter to the collector that he will give appointment to the persons, those who are projected affected persons. That letter under Annexure 2. So when no action was taken, then again agitation was made, and under Annexure 3, there was a policy decision, my lord, there is a meeting, the proceeding of 5th proceeding, under Annexure 3, page 11, my lord. And
the 28 persons who are present there, the names of their under annexure 1, they are present. That is page 20. Including the MLA, concerned MLA, MP, collector, sub-collector, all were present in that meeting regarding employment of the project affected persons. The relevant persons, my lord, I can to draw attention page 11, 12, column 3.1. That is employment. May I read, my lord? 3.1 point. The meeting proceeding, my lord. Annex 3, page 12. In 3.1, my lord, in that the name of the petitioner, that is serial number 3, has been taken, has been enlisted to give appointment as he is a PAP, project affected persons. Total, my lord, 28 persons in page 13. 28 persons were enlisted and recommendation was made to the Vedanta to give the appointment. My lord?
Para 12 and 13 of the counter affidavit filed by Vedanta.
Para 1.3, my lord.
Well, then. Para 1.2 and para 1.3.
My lord. That in reply to the statement made in paragraph 2, it is hereby submitted that an undertaking dated 22/3/2007 has been submitted by the Vedanta Limited to the collector Jharsuguda, stating that the provisions of Odisha RR policy 2000 will be followed. It is pertinent to here note that the collector Jharsuguda has confirmed the 5th RSC meeting dated 19/11/2011 that one-time cash payment in lieu of employment has already been given 71 numbers of PDFs, that the respondent company VAL has provided direct employment to 74 numbers of PDFs, RR policy 2006, annex 3 of the writ petition. Then, my lord, that in reply to the affirmation made in paragraph 5, it is submitted that the petitioner belongs to the family of only PAP, affected person, and not of displaced family. Therefore, in accordance with RR policy 2006, the petitioner was not entitled for any consideration of employment as a matter of right. Moreover, as stated in the letter dated 16/10/2008, a survey was to be conducted for shortlisting and consideration of PAP graduates for employment in partners associate companies of Vedanta after approval of district administration. A total 37 of PAP graduates were identified through the survey and consultation from the respective village panchayat through Sarpanch, and in due consultation with submitted to the district administration. Subsequently, it is important to mention here that they were employed directly in the roles of Vedanta Limited. Further, it is pertinent to mention here that petitioner was unqualified as he was still studying at the time of socio-economic survey and therefore was not eligible for consideration for employment. So that is not true, madam. Because
no, if it is not true, you have not filed any rejoinder.
And because why because that is the under answer 3. My qualification has been written in itself in the meeting. Page 13, madam. Page 12. Each meeting was held by the RDC collector and everything. They have written my name. Page 13, page 12. Serial number 3, the Prashant Nayak. My qualification is BA.
May I interrupt for a moment here?
No.
Only for a limited purpose. This question only, other I will go. That my learned friend is showing is meeting of 2013. This survey was conducted in 2009. So while 2009 the survey was conducted, he was a student. That is what submission. Let my learned friend proceed.
No. Now that he's a graduate,
that 2013 he was a project affected person. Project affected persons have no entitlement. Only project displaced persons have under 2006 RR policy. So he was never entitled, and this recommendation of the RPDAC was also not to give him employment. It was only that these persons are project affected. If they suit in or they are qualified otherwise, then their appointment may be considered. But he was never, my lord, that qualified for which his appointment should have been considered at that point of time. 2013, now it is 2022. And by the time acquisition was made, that was in 2009. My lord, so otherwise also he is not waiting for the appointment since last 12, 13 years.
And they've also
May I come in?
already paid
Let's say,
compensation.
may I point out certain things, madam?
No, they've already been paid land acquisition compensation.
Yes, yes, madam. I am coming from the by. May I complete, madam? Submit, madam. See, under Annex 3 was a recommendation. I am coming because they have given appointment some of the persons out of that list. That is my and they have discriminated to me.
Now,
So
for that purpose only that
I made complete. Why are you interfering? You will say, man, you will submit. Court will allow to you.
No, just for clarification. because
Yes,
that was
you
that was
give the
order of
clarification.
Supreme
Why you
Court
are
to file reply to
yes,
that
yes. You have
submission.
given.
I filed the
I will
reply.
show all the replies, my lord. Under after RPDSC meeting under Annexure 4, the ADM phase 21 manner. The ADM certainly want to know what action has been taken by the Vedanta. That is the RPDSC meeting that 2011. They written a letter to the Vedanta under Annexure 4 to let me know what action has been taken under Annexure 4. Then also, my lord, the under Annexure 5, the district project office Jharsuguda also written a letter to the Vedanta to let him know what action has been taken. So, my lord, under Annexure 7, I have given that out of 20 persons, they have given 2 persons. That has been also reflected in the order sheet, my lord. Lordship, kindly see the order, my lord. Last order 30/11/2016. This Honorable Court passed the order. This Honorable Court has directed on 30/11/2016, stating that Lord Counsel for the State submits that he has already received instruction and shall filing the counter affidavit within 10 days. Lord Counsel for the State also directed to take instruction and incorporate in the affidavit with regard to the fact that some appointments from out of the list of 28 PAPs as per Annexure 3 have been made, which fact has also been reflected in the representation of the petitioner under Annexure 7. So my respectful submission that under Annexure 3, they have given 2 persons appointment. 28 persons, they have given one Devasis Devadatta Sahu, serial number 8, and also another is Sumanta Panda, that is also serial number 18. Out of 28, they have given 2 persons and not given to the petitioner. So now, Lordship, kindly come to the counter of the government, my lord. OP number 2. The collector has filed the counter, my lord. Paragraph 8. The counter of OP number 2. Lordship, got it, ma'am?
Carry on, sir.
Well, paragraph 8, OP number 2 collector, that in reply to the amendment in paragraph 6 of the writ petition, it is humbly submitted that the column 3 of the 5th proceeding of rehabilitation policy dated 19th November 11, as directed upon by the petitioner, recommends list of 28 persons of PAP families to be considered for employment by Vedanta Ltd. It is pertinent to note here that the said list is put up for consideration for employment, but till date, no action has been taken by the project authority, that is Vedanta. That is the government counter, madam. Then, Lordship, the counter of the Vedanta, Lordship has pointed out, just before that, I am also point out to the paragraph 9 of that Vedanta OP number 3, Vedanta counter, madam. Paragraph 9. My lord, that the amendment made in paragraph 1 of the writ petition is disputed and denied. It is submitted that the petitioner is not a member of the PDF as enlisted under the socio-economic survey undertaken by the respondent number 3. The petitioner, however, belongs to a PAP category as enlisted in 5th proceeding of rehabilitation policy held on 19/11/2011 to the writ petition, Annexure 3 to the writ petition. Therefore, the said petition is not eligible for the consideration of employment as obligatory and mandatory under Orissa RR policy, and not like the circumstances has been adequately compensated for the loss of the land. So, my lord, when they have given 2 persons out of 28, and how they are denying the petitioner is not belong to that capacity, my lord, they have filed their additional reply regarding the appointment of 2 persons. Now they have taken a stand in their reply affidavit, my lord. Reply affidavit running page 2. That has been
Para 6. Come to para 6 of the reply.
Para, my lord, page 2, last para.
Yes, para 6.
Para 6.
No para has been mentioned in my copy.
It is there. It is there.
6. 6 last para. 6 last para. So far as the question of appointment of 2 persons, that is Devadatta Sahu, ID number 8, out of the list of 28 persons, it is submitted that both the recruitments were made through transparent recruitment system based on merits of education, age and language requirement. It is to be noted that one of the 2 persons hired, that is Sumanta Panda, was the first person to hold in an MBA degree in his town. It is pertinent to note that the Devadatta Sahu was recruited in the 2009 itself, that the list was created producted in 2011. As far as Devadatta Sahu is concerned, this appointment took place in 2009, prior to the publication of the list of persons placed before the RPDSC. Therefore, it is clearly shows that the above recruitment has no reasonable nexus with the list. The recruitment is independent of the list. That the only reason why these 2 people were engaged is because they were considered on merits and requirements of the position. It is merely a sheer coincidence that means both the persons are on the list. Therefore, the contention that these 2 people were considered only because their name was in the list is completely negated. Hence, the contention paragraph is denied. But they have taken, when they have already listed in the 28 persons list and given appointment, now are saying that they have got the appointment order merits. And so far as Sumanta Panda, my lord, the appointment order they have annexed, running page 17. The Sumanta Panda who has enlisted along the 28, the page 17, that is dated 7/2/2012, after the RPDSC meeting, and they have given appointment to the Sumanta Panda. So when they have given some of the persons, they are the enlisted persons of proceeding, they have discriminated to the petitioner. And how they will say that?
Anything else?
No, ma'am.
All right. The petitioner is aggrieved by the action of Vedanta Aluminium Limited, bracket opposite party number 3, in not granting the petitioner employment in the company pursuant to the Orissa Rehabilitation Resettlement Policy 2006. Full stop. Admittedly, the acquisition question took place in 2009. The policy broadly categorized the persons losing land as project displaced families, bracket PDFs, and project affected persons, bracket PAPs. So there is no dispute that the petitioner falls under the category of PAP and not PDF. Paragraph. In terms of the R&R policy, while one person in a PDF would be granted employment, there was no such guarantee as far as the PAP was concerned. This clearly emerges from the counter affidavit filed by opposite party number 3. Full stop. As far as PAPs are concerned, they would be given cash compensation in lieu of no, they would be compensated for the loss of land with no guarantee as to employment. It is stated that as far as the petitioner is concerned, his grandfather was not a displaced person. And in terms of the socio-economic survey, read with the RNR policy, open quotation, said family is only an affected family and not a displaced family, unquote. Nevertheless, it appears that a survey was conducted for shortlisting and consideration of PAP graduates for employment in the partner/associate companies of Vedanta Limited after approval of the district administration. A total of 37 PAP graduates were identified through the survey. At the relevant time, the petitioner was stated to be open quotation, still studying, unquote, and therefore not eligible for consideration for employment. Paragraph. Counsel of the petitioner has relied on a list of 28 persons of PAP families whose names figured in the fifth proceeding of the RPADC dated 19 November 2011. Full stop. Counsel of the petitioner submitted that only 2 of this list were considered for employment and others, including the present petitioner, were discriminated against. Paragraph. A further affidavit dated 24th April 2017 has been filed by Vedanta Limited, where in respect to the 2 persons appointed, it is stated as under, take from that affidavit, bottom of page, internal page 2 and top of page 3. Paragraph. There has been no rejoinder filed by the petitioner to contradict the above facts. Full stop. If indeed the 2 persons were employed on their own merit, then there cannot be said to be any discrimination vis-a-vis the present petitioner. Full stop. Paragraph. Having considered the submissions of learned counsel the parties, the court is satisfied that the petitioners failed to make out a case for grant of the relief as prayed for. The petition is dismissed.
Special weekly list item 53.
No instructions.
Counsel, the petitioner states he has no instructions. It's disposed of.
Special weekly list item 54.
No instruction.
No instructions. Dismissed.
Special weekly list item 55.
55, it has become infructuous.
Counsel, the petitioner states it's become infructuous. Disposed of.
Special weekly list item 56.
56, my lord, no instructions. No instructions.
Your lordship may note my presence.
Yes.
In 56.
Lord, your lordship may note my appearance, my lord. I am for OP number 1.
All right.
Special weekly list item 57.
May I please, my lord? I am in the BC, my lord. My lord, the grievance of the petitioner is, though as per the reference, the learned tribe, the reinstatement was ordered, but back wages was refused, my lord.
And again, compared to
Yes, please continue.
Yes, my lord. My lord, your lordship may kindly come to page 8 of the internal page 4 of the award, my lord.
Yes.
These are the findings, my lord. On perusal of the pleadings of both the parties, affidavit evidences of second party workmen and the documents filed by the workmen, it is clear that while the second party workmen were working under the management, they were placed under suspension, though the management has taken the plea that as the explanations of the workmen were found unsatisfactory, they were placed under suspension, charges were framed, and domestic inquiry was initiated against them, to which the workmen have categorically denied regarding framing of charges and conduct of any disciplinary inquiry. Moreover, the management has also not filed a single piece of record paper to show that the domestic inquiry was initiated by the management against them, and due to their non-cooperation, the domestic inquiry could not be completed. So, without any documentary evidence, the oral evidence cannot be. You will also see the next page. Page para 8, my lord. here though the reinstatement order was made, but it was refused that because they have not worked, the workmen have not worked. Well, they were terminated. How can they work?
No,
that
you're
period.
mistaking. You're mistaking. You
Sorry,
have to
madam.
show that during the period you are out of work, you were not gainfully employed elsewhere.
It is nobody's case was they were employed, my lord.
Yes, yes.
It was not the.
That is the question framed, sir. Just come to that question so far as back wages, para 8.
Para 8, that is the finding, my lord.
No, that is the law, sir. You have to show that during the period that you were out of work, you were not gainfully employed elsewhere. That burden is on you.
That was never raised, my lord. I was not employed.
No. The labor code is not obliged to simply grant reinstatement with back wages if you do not satisfy this requirement. The court can certainly ask the question whether were you gainfully employed or not.
The evidence was laid. The other side has appeared. This question was never put to him.
Yes.
It was never because the non-employment, the non-working was not due to the fault of the workmen, my lord. It was because
you're completely mistaken on that, sir. The question is not about working in that establishment. Whether you were gainfully employed elsewhere during the time that you were out of service, that is the question.
It was never the case of the management also, my lord.
No. All right. Anything else, sir?
I don't think any other thing can be raised.
Counsel for this is a petition by the workmen challenging an award dated 28th May 2013, passed by the Labour Court, Bhubaneswar, in Industrial Dispute Case number 5, 2011, paragraph. The grievance of the workman is that after finding the termination of the services of the workmen to be unlawful, the Labour Court stopped at directing the reinstatement but denied them back wages. Paragraph. It is seen in para 8 of the impugn award that the Labour Court is observed as under. Reproduce the whole of para 8. Paragraph. Counsel for the petitioner urged that the petitioner could not be expected to be employed when they were in fact out of employment. Full stop. This is a complete misunderstanding of what the Labour Court has pointed out above. Full stop. It has been pointed out that the burden of showing that the workman was not gainfully employed elsewhere, while he was out of employment with the management, was on the workman. Full stop. This, the workman is not discharged. Paragraph. It is then argued that this was not an objection raised by the management to the prayer for back wages. Full stop. The Labour Court was not obliged to grant such relief without being satisfied on the issue whether the workmen in question were not gainfully employed elsewhere. Full stop. In other words, the Labour Court is not committed any error in posing the above question and placing the burden in that regard on the workmen. Paragraph. Consequently, the court is not inclined to grant any relief as prayed for. The petition is dismissed.
Special weekly list item 58.
My lord, my name may be recorded for the opposite party management.
All right.
Counsel for the opposition.
Special weekly list item 58.
None appears. Dismissal not possible.
Special weekly list item 59.
My lord, item 59, no instructions.
No instructions dismissed. Right.
Special weekly list item 60.
Item 60, my lord, this matter was directed to be listed along with other matters by order dated 6/7/2022.
On the 27th.
List on 27th. With what? What's the petition number?
With WP within bracket C number 284428 of 2013.
All right. With all those questions. All right. All right, sir.
Special weekly list item 61.
Then appears to succeed. Counsel for the petitioner states he does not wish to press the matter. Dismiss is not pressed.
Special weekly list item 62.
Item 62.
My
And
lord,
for-
I request for a passover, your lordship.
All right.
Special weekly list item 63.
None appears. This is not.
Special weekly list item 64.
None appears. This is not.
Special weekly list item 65.
75.
65.
60.
None appears. This is
Special weekly list item 66.
None appears. This is not.
Special weekly list item 67.
My lord, on behalf of S.K. Patnaik, who is the arguing counsel, he is a corona positive, my lord.
What is the matter about, sir? Tell us. Tell us what the matter is.
That is challenge order of
Before my learned friend starts, may I just
my lord.
one, if your lordship will permit me, just one fact which I want to place with your lordship. The man is today 80 years old. The direction is to pay him 75,000 odd rupees.
Right.
My lord, Mr. Patnaik is corona positive. That's why I am praying for time, my
The
lord.
interim order, sir.
My lord, interim order
Subject to depositing of 75,000.
already deposited before this honorable court.
Then that can be released straight away, sir.
My lord,
Let that be released straight away.
my lord, I am praying
We'll
for
hear it on any other day.
on the
We'll
ground
release
of
the
the corona
Let it not
positive.
wait any longer, sir.
That is
Let the amount be released. 75,000 is not much.
much, my lord. That is
Correct. We'll hear you on some other days.
Yeah,
We'll
public-
hear you on some other day, but the amount be released. You say the opposite party workman is today 86 years old.
80 years old.
80 years old. The only relief granted to him by the labor code was compensation in the sum of rupees 75,808. Full stop. While granting an interim stay of the impugn award on 24th February 2014, this court had directed the petitioner to deposit the said amount in this court. Full stop. Counsel to the petitioner confirms that the deposit has so be made. Paragraph. Considering the age of the opposite party, the court directs that the amount deposited be released to him forthwith upon proper identification by the registry, together with whatever interest has been accrued thereon. Paragraph. The MC number 22666 of 2013 is disposed of. In the main writ petition, you say, counsel the petitioner is stated to be indisposed.
My lord, this is not compensation. This is the unutilized leave salary.
All right. Unrealized leave salary. All right.
In this case,
List for final hearing on 22nd November. All right.
Pardon your lordship, my lord, item 65 on behalf of Mr. R. Achari.
Which is the item we are in now?
We are in 67.
67. All right. Yes.
My lord, item 65 may be pardoned on behalf of Mr. R. Achari. My lord, in this matter, we have issued notice and till date, there has been no appearance from the opposite parties.
Carry on, sir. Argue the matter.
The lordship, this is a matter relating to no dispute award, which is under annexure 4 and 6. Your lordship may kindly have a glance to annexure 4.
Yes.
Lordship, running page number 15. Fourth line, your lordship, where it says it might be that the dispute has been settled amicably between the parties out of the court. Lordship, may kindly have a glance to the it might be. There is a probability, your lordship. And in annexure 6, I have made representation for restoration of the petition under annexure 5.
There's no such provision, I think.
Lordship?
There is no provision for recall and all that.
Yes, your lordship.
There is no such provision, sir.
Lordship, may kindly have a glance to the judge. Lordship, AIR 19.
Anyway, you'll still have to tell us why you did not file a statement of claim.
Lordship?
Kindly come to the bottom of page 14 and top of page 15.
Yes, your lordship. both the parties are absent. My lord, due to some personal inconvenience, that the parties was.
This is all not satisfactory, sir. This is not convincing. It's not such a casual exercise. You're coming to a high court challenging an order of the labor code. You have to come up with far more serious contentions.
My lord, lordship may kindly come to Annexure 6, where it has stated any order passing no dispute award cannot be recalled.
Sir, assuming they could have recalled, you are arguing in 2022, you still have to satisfy us that you had valid reasons not to appear in the labor code, correct?
Yes, Your Lordship. But Your Lordship, since 2013 notice has been issued, but no one has.
So it has to be allowed. If no one turns up on the other side because notice is not gone, we have to allow the petition. You don't have to satisfy us.
Yes, Your Lord.
By default, it has to be allowed because there is no opposition. Should you not satisfy us, sir?
Yes, Your Lordship.
How are you satisfying us that the impugned order is wrong?
My Lord, may kindly have a glance to the judgment of.
What does it say, sir?
My Lord, it says industrial setting aside does not amount to review tribunal.
What will happen, sir? Suppose we agree with you with this judgment. What will happen? It will go back to the labor court.
Your Lordship,
it will not go back, sir. It will only go back to the stage of recall, right?
Yes, Your Lordship.
Unless again to that labor court, what do you have to satisfy? Why you are not present in the labor court? You have to satisfy the labor court.
Yes, Your Lordship.
We are asking you to satisfy us because it's 2022. 9 years have passed. You satisfy us.
Your Lordship may kindly direct for recall, and I'll re-examine it. And
why should you
satisfy Your Lordship?
Why waste your client's time? If again the result is the same, what will happen if we follow this judgment? The labor court has to hear the recall application, correct?
Yes, Your Lordship.
In the recall application, the labor court is not satisfied because we are also not satisfied. Labor court is not satisfied. It's saying not satisfied. I am not recalling.
My Lord,
not because it does not have power. It says on merits, I find no power, case made out for recall. Recall petition is dismissed.
My Lord,
then you'll again come to this court. Again, we'll ask you the same question. Why go through this exercise, sir? So why don't you satisfy now only?
Lord, the petitioner was absent for just one day and on that day only he has been.
Naturally, whichever day the person is absent, that day only ex parte award, that day only default award all will be passed. Only on the day the person is absent. So why was he absent is the question.
Not due to personal inconvenience, which was unavoidable.
Are you satisfied? Are you satisfied with this kind of argument? You're trying to satisfy a high court. Are you satisfied?
The Lordship may keep it on
no,
the day.
This is a very small point. There's nothing for tomorrow, day after and all. That's a short point. All right. The petitioners agreed by an order dated 15 July 2013 passed by the Labour Court, Bhubaneswar, declining to recall a no dispute award passed by it on 2nd January 2013, industrial dispute case number 50 of 2012. Paragraph. Relying on the judgment in
AIR 1981 Supreme Court 686, Your Lordship.
Counsel to the petitioner. No cost title, sir. There's only one AIR. Are there names of parties?
Not Greenlays Bank Limited appellant versus the Central Government Industrial Tribunal and others.
All right. Greenlays Bank versus CGIT. Counsel to the petitioner argues that the Labour Court should not have rejected the recall petition on the ground that the award had already been gazetted by the state government. Paragraph. It is seen that the no dispute award was passed by the Labour Court on 2nd January 2013 in the absence of both the workmen as well as the management. But sir, it is noted how the case was fixed for filing of statement of claim by the workman, but no claim had been filed, open quotation, despite sending 2 registered notices to him on 27/9/2012 and 6/12/2012. Unquote. Accordingly, the Labour Court concluded that, open quotation, the second party workman is not interested to proceed with the case any further. Full stop, unquote. The Labour Court surmised whether the disputes had already been settled between the parties. Paragraph. Assuming this court accepts the plea of the counsel for the workman that the recall application ought to have been considered on its merits, still the workman has to give sufficient cause for not appearing before the Labour Court on the date fixed. Full stop. More importantly, the workman has to satisfy the court why, despite being sent two registered notices, he did not file a statement of claim. Full stop. The only response this court has received from counsel for the workman is that, open quotation, due to some inconvenience, unquote, the workman could not appear in the Labour Court. Full stop. This explanation is found to be wholly unconvincing and unsatisfactory. Full stop. It would be a really futile exercise in the face of such explanation to even ask the Labour Court to reconsider the recall application. Consequently, the court finds no error committed by the Labour Court in rejecting the recall application and in passing the no dispute award. The petition is accordingly dismissed.
Special weekly list item 68.
Okay.
My lords.
Yes, please.
Here is also the petition has similar matter, my lord. Due to non-appearance of the conducting counsel, the date fixed, my lord, the matter was set expertise and expertise award was passed. Thereafter, immediately the petitioner filed application to recall that order, my lord, set aside the expertise order. But the Law and Trial Court, Labour Court, has rejected the same on the ground that sufficient ground has not been assigned. That's why my 913 application was rejected, my lord. Against that, the petitioner is withdrawn, my lord.
Yes.
The only ground was assigned that the conducting counsel was not present due to his personal inconvenience, my lord.
So here there is no stay granted. Oh, there is a stay. Oh.
Noting, my lord,
What's the age of this workman, sir?
At that time,
So by staying a dismissal of your recall set aside petition, how does the award get stayed? Doesn't it stayed? The award doesn't get stayed.
Minor.
Did you get a stay of the award?
Petition of the order, my lord.
With 50% back wages, he has to be reinstated.
My lord, age, I am unable to get the age, my lord. Yes. Sorry, my lord, the age is not with me, my lord.
So what's the reason for not approaching within 30 days, sir? No reason.
No reason, my lord, only the inconvenience,
That's all.
the
You
matter was
say the
not
challenge by the
intimated to
management in the present petition is to an order dated 19th May 2012, passed by the Labour Court, Bhubaneswar in Industrial Dispute Case 29 of 2003. And the subsequent order dated 17 June 2013, passed by the same court, dismissing an application filed by the management for setting aside the ex parte award dated 19th May 2012. Paragraph. It appears that the management was set aside, set ex parte on 16 March 2012 itself, because despite several opportunities, none had appeared on its behalf. On 19 May 2012, the ex parte order came to be passed. Full stop. It was published on 4/8/2012. Full stop. After waiting for more than 30 days after its publication, the restoration application was filed on 18 September 2012. Full stop. Paragraph. The Labour Court has rightly noted that after the publication of the award, the court itself became functus officio. Full stop. Moreover, sufficient reason was not provided by the management for not appearing before the court on 16 March 2012 and then waiting till 18 September 2012 to file the restoration application. The only reason given was that its counsel had not single quotes cooperated, unquote. Full stop. The above explanation was rightly rejected by the Labour Court. Stop. The court is not, therefore, this court is also not satisfied that any valid justification has been provided by the management for not appearing before the Labour Court on the date fixed and for the delay in approaching it for restoration after passing of the award. Consequently, the court finds no reason to interfere. The petition is dismissed.
Special weekly list item 69.
Interim order is vacated.
69, I am for OP number 4.
None appears to the petitioner. Dismissal not possible.
Special weekly list item 70.
70, I am for the opposite part number 1.
None appears to the petitioner. Dismissal not possible.
Special weekly list item 71.
One minute, there is a delay of 315 days.
The delay of 315 days is not satisfactorily explained. Petition is dismissed.
Special weekly list item 72.
May it please minutes. Minutes, I appear on behalf of Mr. Acharya. Your Lordships, I appear for the sub-item 1, that is Anand Auto. This is STREV 59 of 2013.
Yes.
Your Lordships, this is a sales tax revision which arises out of the order passed by the Sales Tax Tribunal dated 27/7/2011. Your Lordships, a very short point of consideration in this sales tax revision is mentioned in page number 9 of the petition, which reads as follows: whether on the facts and in the circumstances of the case, the Honorable Orissa Sales Tax Tribunal was justified to treat helmets as unspecified goods subject to tax at the rate 12%, overturning the order of the Learned Assistant Commissioner of Sales Tax, who held helmet to be classified as an accessory under entry 169 of list C of OST Act, subject to tax at the rate 8%.
What is that entry 167? Let's see.
Your Lordship, entry 167 reads as spare parts, accessories and components, parts of motor vehicle /2/3 wheelers, machineries
helmet is not all that, sir.
But
helmet is something that you wear on your head. It's not part of the machinery.
But Your Lordships,
it's not an accessory of the machine.
It is, your lordships is absolutely correct. But in my sales tax revision, this petition, your lordships, as per section 129 of the Motor Vehicles Act, which is mentioned in page number 9, states that every person riding a motorcycle has to wear a helmet.
That is okay.
Your lordships,
Does that
without
make the helmet an accessory of the scooter is the question.
accessory,
Does it make it an accessory of the scooter?
it does not. But your lordships, this without wearing a helmet, we are not entitled to ride a scooter.
No, that is all.
It becomes a very integral part of a scooter.
Correct. Yeah.
It becomes very integral part of the scooter that if a rider is not wearing an helmet, or even the
No, that it is necessary for you to ride a scooter is different from saying that it is a component of that scooter, right?
Your lordship, we are not saying that it is a component.
No, this entry is saying that, sir.
This
entry
entry
167
also
is saying that.
This entry also mentions a word accessory. We are solely on the point of accessory, whether the helmet can be termed as an accessory to a scooter or not.
Right.
Yes. So in these terms, as if we go by the definition also, your lordship, which is in the page number 6, as in the Webster's third New International Dictionary, accessory has been defined as an object or device that is not essential in itself, but that adds to the beauty, convenience, or effectiveness of something else. So in that case, your lordship's helmet becomes an accessory to the scooter as well as to the rider.
All right. We are not with you, sir.
Sorry, your lordship.
We are not with you. You see, this revision petition is directed against, arises from an order dated 27 July 2011, passed by the Orissa State Sales Tax Tribunal, Cuttack Tribunal, allowing the state's SA number 1436 of 2006-07 for the year 2003-04. The question sought to be urged by the petitioner for consideration to this court reads as under. Reproduce the question from top of page 9 of the petition. Paragraph. The background facts are that the petitioner carries on business of two-wheeler spare parts, accessories, components, and cycle parts on wholesale cum retail basis in Cuttack. For the year in question, the sales tax officer passed an assessment order under section 12(4) of the Orissa Sales Tax Act 1947 (OST Act) by enhancing the petitioner's sales turnover by adding 10% profit. It is also found that the SSE had paid sales tax at 8% on the sale turnover of single quotes helmets. Holding that it was amenable to sales tax under the heading single quotes other goods, all other goods, unquote. The tax liability and as an unspecified goods. It was taxed at 12%. Paragraph. Agreed, the SSC went before the Assistant Commissioner of Sales Tax, who by the order dated 27 September 2006 agreed with the SSC that helmet should be considered to be an single quotes accessory, which is exigible to sales tax at 8%. Paragraph. The state then went in appeal before the tribunal. Paragraph. After discussing entry 167 of list C of the rate chart under the OST Act, the tribunal observed that open quotation, what articles are to be treated as accessories and component parts of motor vehicle /2/3 wheelers have not been specifically mentioned in the said entry. Unquote. It was noted that helmet is open quotation never fitted to the motorcycle, but it is used by the driver of the motorcycle while driving the same. Stop. So helmet cannot be treated as an accessory for the motorcycle in any sense. Unquote. For the aforementioned reasons, the order of the SC/ST is set aside and the order of the STO is restored to file. Paragraph. Learned counsel for the petitioner refer to the dictionary meaning of the word accessory. And submitted that it would form an essential part of a two-wheeler. We'll stop referring to the requirement under Section 129 of the Motor Vehicles Act 1988, which mandates the wearing of a protective headgear. It was sought to be contended that without a helmet, a scooter or two-wheeler cannot be driven. Therefore, the helmet would satisfy the definition of an accessory. Namely, even though it is not an intrinsic part of the vehicle, open quotation, adds to the convenience or effectiveness of the same. Unquote. Full stop. Reference was made to the decision in Annapurna Carbon Industries versus State of AP, 1976, 37 STC 378-SC, where it was held that accessories may not be confined to particular machineries for which they may serve as aids. So in Mehra Brothers versus Joint Commissioner of Tax Office, Joint Commissioner 1991 80 STC 233-SC. It was held that car seat covers and upholstery are to be treated as accessory of motor vehicles. Stop. Likewise, in Pragati Silicon Private Limited, CCE, 2007 9 SEC 470, nameplates were to be treated as accessories. Stop. Paragraph. Having considered the above submission, it appears to the court that the requirement that a helmet does not fit into the items listed out in entry 167 of list C of the rate chart appended to the OST Act, which reads as under reproduce 167. On the other hand, entry 189 is like a residual entry, which reads open quotation all other goods. And for which the rate of tax is prescribed as 12%. Paragraph. In the setting in which it occurs, that is between the words single quotes spare parts and single quotes component parts, the word accessories can mean only something that is an integral part of the motor vehicle or 2/3 wheeler and machinery. Full stop. The question to be asked is whether the two-wheeler by itself will not be a two-wheeler without there being a helmet. Full stop. The helmet is something worn by the rider. Full stop. It may be mandatory in terms of the MV Act, but
Section
By
120.
that reason, it does not make it a component part of the 2/3 wheeler. Full stop. There is a distinction to be drawn between car seats without which the car would not be complete, which is very much part of a car. And for that matter, even a nameplate, registered nameplate, without which the car would not be complete. A motorable car would not be complete. So stop it. The same cannot be said of a helmet, which is not something permanently attached to the motor vehicle or 2/3 wheeler, and becomes an integral part of such 2/3 wheeler. So it is something still external to the vehicle itself, although it is to be mandatorily worn by the rider. Consequently, the court concurs with the tribunal that a single court's helmet cannot be said to fall within the scope of entry 167 of list C of the rate chart appended to the OST Act.
I may be, pardon your lordship, just a small point, ma'am. Your lordships, in this Annapurna carbon, it was held that the car seat covers and not the car seat.
All right. The petitions accordingly. The court is not therefore inclined to frame the question as urged. The petition is dismissed. All right.
In the connected STRV is there, 71/2013. That's by the state. Here the tribunal has held the reverse. The helmets and box to be accessories. So that is what the state has challenged. So in view of this, my lord, the question of law here.
All right. You say admit following question is a frame for consideration in the present petition, which arises from an order dated 20th April 2013 of the Orissa Sales Tax Tribunal, allowing the assessees SA number 1067 of 2005-06 we take the question from question 2 at page 8. In view of the order passed by this court today in STREV 59 2013 bracket Anand Auto versus State, unquote. The above question is answered in the negative. That is in favor of the revenue and against the department and against the SSC. In this, notice is not gone.
No.
Oh, notice is not gone, is it?
Yes, my lord, it has gone. The noting is that postal ID issued to OP returned back, but no one appeared on behalf of OP. It is gone. But no one is appearing.
All right. So this question is answered in the favor of the department and against the. Right in the beginning, you said despite service of notice, none appears for the opposite party. All right. So petition is allowed in the above terms. The impugn order of the tribunal is set aside. Yes.
Special weekly list item 73.
My lord, the question of law is at page 13.
Is it after notice or before?
No, question of law has not yet been framed. my lord.
Notice is not gone.
No.
So let's see what the matter is about.
Whether the activity of news printing is manufacturing. That's the question of law at page 13.
Printing on the newsprint is manufacture.
Yes, my lord. That is being contended by the dealer. That is what is being contended by the dealer.
By the dealer?
Yes. He says if it is a manufacturing process, then the raw materials he is purchasing, that is to be taxed at the 50% of the rate. If it is a manufacturing. So he is contending it to be a manufacturing process. And that's what the tribunal has held, and hence the
No. So it won't be scheduled goods then under the OET Act.
The next question is, since the newspaper itself is not a scheduled good, that means the manufactured article is itself not a scheduled good, so you are not entitled to that concession also. That concession of 50% on the raw materials. So these are the two questions of law. Madam.
Let's see the tribunal's order.
Page 23, it starts, Mala. Page 25. Rule 3 of the OET rules has been quoted. That says the tax payable by the dealer or any other person under the Act shall, subject to the explanation hereunder, be at the following rates. 4. Goods specified in Part 1 and Part 2 of the schedule to the Act shall be exigible to tax at a concessional rate of 50% of the rate to which such goods are exigible under section subrule 3 and subrule 2 respectively of this rule when such goods are brought, he is claiming it to be B, for use as raw material by a manufacturer on fast entry into a local area from another local area. A bare reading of this rule, it clearly spelled out that the goods specified in Part 1 and Part 2 of the schedule to the Act shall be eligible to tax at 50% of the rate to which such goods are exigible under subrule 3 and 2 respectively. To this rule, when such goods are brought for use as a raw material by a manufacturer on fast entry into local area or state from outside the state. The newsprint in this case has been specified at serial number 14, Part 2 of the schedule, and that too it is a scheduled good. Newsprint, no doubt, is a raw material for newspapers. Therefore, the respondent has been granted a license stroke registration to the effect that he is a manufacturer. He purchased newsprint as raw material for printing newspaper on it. Therefore, he is entitled to.
So what is wrong with it? Because this blank newsprint is not the same thing as a printed newsprint.
Well, there is no new,
of course, you can't sell that blank, selling a newspaper at 1 rupee and the blank newsprint. Isn't that two different things?
Commercially different article comes out.
Newspaper itself is identified as a separate product from newsprint. It's not the same product. You see, the short questions ought to be urged by the state in the present revision petition directed against an order dated 6th June 2013 passed by the Orissa Sales Tax Tribunal, Cuttack, Tribunal. You see, these petitions dismissing the state's essay number 56 bracket E and 59 bracket E of 2010-11 against the orders dated 8 March 2010 of the DCST bracket appeal and 30th March 2010 of the DCST bracket appeal. For the years, which are the 2 years?
3, 4 and
2003-4,
4 and 5.
And 2004 and 5. Reads as under. Read as under. Take A, B, and C from pages 13 and 14. Paragraph, admittedly, the opposite party SSC purchases blank newsprint and then prints newspapers on it. So consequently, the SSC contended that printing newspapers on newsprint brings forth a commercially different product, having a distinct characteristic use and utility, and therefore amounts to single quotes manufacturing. Unquote. Full stop. It is further contended that as a result, the SSC is entitled to pay entry tax at 50% of the purchase turnover of the raw materials. Full stop. According to the department, the respondent was not a single quotes manufacturer. And open quotation, newsprint, close quotation was not a raw material. Paragraph. It is noted that
Page 5, paragraph 5, the
Yeah,
process
yeah.
of manufacturing.
printing of newspaper and newsprint did involve a manufacturing process. While newsprint was a scheduled good, as specified at serial number 14 of part 1 of the schedule. It did constitute a raw material for a newspaper. So the act of printing ink on the newsprint and therefore bring about a newspaper involved a process which resulted in a distinct and different product. The SSC was granted a license of the registration for such printing of newspapers. Full stop. Consequently, the court concurs with the tribunal that the SSC is entitled to the concessional rate of 50% of the rate at which newsprints were exigible to tax. Paragraph. The court is unable to find any error having been committed by the tribunal in coming to the above conclusion. The court is therefore not inclined to admit these revision petitions and frame the question of law as urged. The petitions are dismissed.
Special week list item 74.
None appears to assist not possible. Come.
I'm sorry. This issue is covered by your lordship order dated 6/7/2022 regarding delay in communication of the order.
Yeah, in view of the order dated 6th July 2000.
No, my lord, beg pardon. No, my lord, it is not cover. My lord would see it's order under section 7(3) of the OET Act. My lord would kindly see it's the unamended provision. Section 7(3) of the OET Act, my lord may kindly see. In fact, if my lord is holding the new book, in the at the bottom, the unamended provisions are there. Section 7.
Section 7.
Yes, my lord. 7. Now the new section says return and return demands. Section 7. My lord may see the bottom, the unamended.
Yes.
7. 7(3). It's the assessment order section 7(3). And it doesn't provide for any limitation, my lord. This section 7 doesn't provide for any period of limitation.
My lords, may I please? My lords, may kindly see Rule 30 through 34 of the OET Act, which provides the provisions of Orissa Sales Tax Act will be applied. The provisions of Orissa Sales Tax will be applied. And under the OST Act, 3 years of limitation is provided, my lords.
In the OST Act.
Yes, ma'am.
In the substantive.
No, the OVAT Act, right?
OET Act, my lord.
OET Act, my lord. OET Act provides under Rule 34 provides that the provisions of OST Act will be applicable.
No, it says VAT Act. Now it says VAT Act.
Now it says, my lord, during the relevant provision
The
2004,
OST
5,
Act
my
will
lord.
apply.
Yes, my lord. OST Act provides 3 years period of years
And
of
therefore this judgment applies.
my lords.
But the substantive provision under the OET Act having not provided for any period of limitation,
No, but this Rule 34 will clearly apply.
My lord, the 34, my lord, in case it is not provided here, then that will apply. Here, the substantive provision doesn't provide for any period of limitation. So
that will apply, right? Isn't it?
my lord, so the
It does not-
OST provisions cannot be borrowed here, my lord.
No. For matters not specified, since limitation is not specified, that act will apply.
My lord, the legislature has knowingly not provided for any period of limitation here, unlike
There's already an OST Act.
And the OST Act says, my lord,
Then they should not have put Rule 34. Rule
My lord?
34 says for something for which this act is silent, the OST Act will apply.
And my lord, the OST Act also says, and this order has been passed on 31st March. So it is within the period of limitation. What he says that it has been served later. That's why it is. Madam, may kindly see the order date. It's 31st March 2008.
When
So
was
it's
it
within the
served, sir?
period of limitation, my lord.
Serving is the most important.
My lord,
So there is no pleading to that effect.
May please. The order has been passed on 31st 2008, but issued on 17/11/2008. My lord, that is the issue, my lord.
Not
They have
only
issued after
sir,
7.5 months.
You're in trouble even in issuing. You're keeping it in the file for 8 months. This is not even about postal delay. This is failure to issue it at all. You see the present revision petition arises from an order dated 6 June 2013 passed by the Orissa Sales Tax Tribunal dismissing the petitioner's essay number 190 bracket ET of 2009-10 for the year 2004-5 paragraph. One of the pleas raised by the petitioner was that the assessment order had been framed on 31st March 2008. But the assessment order was issued only on
17/11/2008.
17/11/2008. And therefore, the assessment itself was time barred. In terms of the 3-year limit is where?
Section 12(4), my lords, OST Act.
Section 12 bracket 4 of the Orissa Sales Tax Act 1947 bracket OST Act paragraph. The tribunal did not accept this plea by proceeding the basis that the date of framing of the order was sufficient to bring it within limitation. Paragraph. Admit the following question of law is framed for consideration. Questions 1 and 2 at pages 10 and 11. This court has heard the submissions of Mr. Agarwal, learned counsel appearing for the petitioner, and Mr. S.S. Padil, understanding counsel for the department. Paragraph. Mr. Padil sought to contend that under section 7 of the OET Act as it stood at the relevant time, 7 bracket 3 of the OET Act as it stood as the relevant time, there was no period of limitation prescribed for completion of the assessment. And therefore, the contention of the SSC in this regard ought to be rejected. Full stop. He further pointed out that once the assessment order was passed on 31st March 2008, it should be held that the assessment was within time in any event. Paragraph. Admittedly, the assessment order was issued only on 17 November 2008, and therefore the question of it being communicated to the SSC prior to that date did not arise. Stop. Unless the order was actually communicated to the SSC, it could not be said to be an effective order passed in terms of Section 7, Bracket 3 of the OET Act as it then stood. Paragraph. The period of limitation is brought in by virtue of Rule 34 of the OET Rules 1999, which states that for any other matters not specified in these rules, the provisions of the OST Act and rules made thereunder would, single quotes, mutatis mutandis apply. Stop with the Act being silent on the period within which the assessment order is to be passed. The provisions of the OST Act would straightaway get retracted. Full stop. Paragraph. In the context of a similar question that arose under the CST bracket Orissa rules 1957 involving the same SSC. This court has, by its order dated 6 July 2022, in STREV 100 of 2013, bracket Messrs. Kirpal Alloy Street Private Limited, Bargarh, versus State of Orissa, held the assessment to be barred in terms of Rule 12, bracket 7 of the CST, bracket Orissa Rules 1957. Following the decision of the Supreme Court of India in State of AP versus M. Ramakrishnaya and Company, 1994, 93 STC 406, bracket SC. Paragraph. By the same analogy, in the present case, it cannot be said that the assessment order was passed within the time stipulated. When Rule 34, when Section 7, bracket 3 of the OST Act, as it then stood, is read with Rule 34 of the OET Rules 1999. Stop. Consequently, the question is answered in favor of the SSC and against the department. The two questions are answered in favor of the and the impugned order of the tribunals accordingly set aside. The revision petition is allowed in the above terms.
Obligation.
Special weekly list item 75.
In this case, I may kindly allow file fresh requisite.
No, not for 2013 matter.
Because I have filed so many repeat.
No.
Memos, but it was not in the list.
Yeah.
To transfer of
This being a
the
9-year-old
concerned
matter.
court, concerned person.
Yeah, we can't give more opportunities for this. The notice of the sole opposite party was returned unserved with the endorsement no such addressee several years ago. So at this stage, the court does not propose to issue one more opportunity to the petitioner for service of notice. Accordingly,
Special weekly list item 76.
76, my lord. There was a non-compliance to the order, my lord, 6/12/2012, my lord. My lord, by 6/12, this honorable directed in this writ appeal, the petitioners have prayed for issuance of a direction to the opposite parties, number 1 and 2, make a joint inquiry afresh to the identity of separate families in the revenue village of Hattibari amongst the original landowners' families and release all the consequent benefits in compliance with the letter dated 3/8/2012 annexure 4 issued by the Principal Secretary to Government of Orissa Revenue and Disasters Management Department, approved in favor of other counterparts without making any discrimination on all the balance amount which has not been paid to them.
So they've already done that.
We have already, there is the affidavit. Dated 28/6/2017.
Correct.
I'm coming to that. Let us go. While disposing by this honorable directed, considering the above submissions, this court directs the opposite part number 1 and 2 to consider the representation filed by the petitioners and dispose of the same within a stipulated period of 6 weeks from the date of receipt of the certified copy of the order, after giving an opportunity of hearing to the parties. So, opportunity of hearing must be given to the petitioners, my lord. Thereafter, my lord, the OP number 2, the contender filed a time petition.
In the time petition, they have stated because it takes some time and they have made the inquiry. On 25/6/2013, they have filed a time petition, my lord. And thereafter, this honorable diet for that. And let us now, my lord, they file a reply. You know, come to the reply, my lord. It is my lord, 28/6/2017. I see occurrence so and so, that in the representation the petitioners have prayed for causing an inquiry to identify separate families in village Hattibari for grant of rehabilitation benefit as per the government policy. On the receipt of representation from the petitioners of the representation, the collector Mayurbhanj has been duly authorized. Who has been authorized? My lord, there is no letter. Only has been the collector Mayurbhanj has authorized. There is not a single scrap of paper filed before the Honorable Court that the collector Mayurbhanj authorized whom, my lord. Authorized conduct inquiry affairs. Where inquiry has been conducted, that is not been annexed to this affidavit. And initiate action as per the prevailing government policy. Prevailing government policy, which policy as per prevailing government policy inquiry has been made, it has all not been annexed. Let them mandate paragraph 5. That although efforts were made to complete the inquiry within the stipulated time period, when efforts has been made, my lord, that has also not been annexed. It could not be contemplated as proper cooperation was not received from petitioners. For enumeration and identification of extended families in the original families, the inquiring officer had to move from door to door, since all the petitioners were not staying in one place, and the whereabouts of the many others were not available, and even some of the petitioners were acting outside. So, who are the petitioners, my lord, not staying there? Who are the petitioners working outside the village? And whereabouts petitioners, that list has not also been annexed to this. Only, my lord, I don't understand that from where they have got this. In the absence of any material, supplies or documents, how this affidavit is filed by the Revenue Tribunal Commission. The inquiry could not be contemplated within the time stipulated of the Honorable Court, although prompt steps and all sincere attempts were taken by the functionaries. That they admit that because due to the non-cooperation of these petitioners, they are not unable to complete. Another next come to that after conducting the inquiry, if there is no, my lord, not a single, my lord, we have not cooperating. How they have completed the inquiry, my lord? The collector Mayurbhanj furnished a proposal of 54 extended families. Those 54 extended families list has not also brought this court before this court. Families for rehabilitation assistance to the government, the Department of Water Resources relating to village Hattibari, out of these government sanctions, the government sanction order is not here. Out of these government sanctions, there is also not a sanction order of the government. Rupees 43,68,000 against 6 eligible extended families and rejected 8 cases as ineligible. Government returned balance 40 cases for further scrutiny, and those lists are also not in the affidavit. So my humble submission, let them furnish a detailed supporting this affidavit. Let them furnish the detailed document so I can get instruction and lordships can adjust the matter.
That's okay.
Or let them supply the documents to us.
Show cause affidavit has been filed way back on 28 June 2016.
And my next submission, my lord, because of my lord, there is a huge money has been, my lord, grabbed by the land acquisition officer. A FIR has been lodged, and ABL PL number 17792 by 2016 has been filed by the land acquisition officer. It has found that 86 lakh some odd rupees has been he has been misappropriated, and 20 lakh some odd rupees has been recovered from his amount, and that the case is going on. That's why they are not, my lord, giving a single document before this honorable court.
You see, on 28 June 2017, a show cause affidavit has been filed by the opposite parties, explaining inter alia in paras 5, 6, and 7 as under. Reproduce 5, 6, and 7. This court has heard the submissions of learned counsel of the parties. Court is satisfied that there has been no willful disobedience of the orders of this court. If the petitioners are aggrieved by the above orders, it will be open to the petitioners to seek appropriate remedies in accordance with law. The petition is disposed of.
May I submit my lord, the Revenue Tribunal Commissioner has filed the affidavit, my lord. Let them, I will make an application, he'll supply all the documents, my lord. Because he has filed the application, the documents must be there.
You can get any order under the RTI Act.
Yes, yes.
Special weekly list item 77.
And they have no onus, my lord, to file the documents without, my lord, with the affidavit.
All right.
There are two.
Yes,
They
sir.
have-
Next item.
Special weekly list item 77.
None appears dismissed or opposed.
Special weekly list item 78.
Item 78, I am appearing for the petitioner. Your Lordship had directed in this contempt case to be listed with the connected writ, that is WPC number 15866 of 2014. That is your Lordship's order dated 6/11/17 may be seen. So that writ is to be connected with this because I have challenged the main order in that writ petition. So this contempt and that writ petition are to be had together. That is the order in the writ and also in the contempt.
What is the date of the order, sir?
Yes, sir. 6/11/17. Let's may kindly see.
Is that still pending here? This 9305/2008.
No, this is writ 15366 of 14.
That number is not there in this order.
No. This in this contempt case, Lordship, may I pray your Lordship to look to the order dated 6/11/17?
Yes, I am looking at it.
Yes. Lord, this is to be listed with along with WPC number 15866 of 14.
No, that's not what the order reads.
Then
It's a
in
different
the
order.
Then in the writ case also, my lord, order has been passed to put all the cases together, my lord. So because what is, my lord, I filed this contempt case, they didn't pass any order pursuant to your Lordship's order passed in the writ petition. Then when they received the notice from your Lordships in the contempt, hurriedly he disposed of my case on a wrong.
How do we know that 2014 matter is still pending?
My lord?
This 2014 writ petition is still pending. How do we know that?
No, that is pending, my lord. My lord, I am appearing for the petitioner.
All right. Mr. Panigrail under senior counsel appearing for the petitioner states that the present petition is to be listed along with writ petition civil.
My lord, WPC 15866.
15866 of 2014. All right.
Yes.
List along with the said petition on 21st November. All right.
21st
Special weekly list item 79.
21st August.
I'm for the opposite side.
None appears dismissed and opposite.
Special weekly list item 80.
Item 80, my lord, infrastructure.
Council petition
Kindly
states
permitted to
petition
withdraw, my
rendered in practice. It is disposed of as such.
Special weekly list item 81.
My lord, I am appearing for the opposite by number 5, my lord.
None appears dismissed and not possible.
Lord, I am the petitioner. I have not received the copy of the counter affidavit of OP number 5.
What's the matter about, sir? Tell us what the matter is about.
The matter is that on a government land, one unauthorized construction has been completed. So for the demolition, the petitioner has prayed for the demolition. In the meantime also, the demolition order has been passed by the BDA and the appeal also has been dismissed and since 2015. But till now, it is not yet demolished.
Who's for the BDA?
My lord, I am appearing for BDA, my lord, on behalf of Mr. Mahapatil. My lord, in this case, my lord, there are some suits are pending in the lower court, my lord, in this case.
Have you filed an affidavit, sir?
Yes, my lord. We have asked regarding the details of the suits. My lord, take some time to file the affidavit.
File the what?
Affidavit regarding the pendency of the suits, my lord, in the lower court.
Counsel for the BDA states that within 4 weeks, a detailed affidavit will be filed, disclosing the present status of the suits stated to have been filed in the lower courts, which are still pending. List on 15th November.
Special weekly list item 82.
My lord, in the meantime, some developments are there. I am also filing the documents, the order of the...
You file it in the registry, sir. Right.
Special weekly list item 82.
82 on behalf of Mr. R. Achari, Your Lordship, the matter has become infructuous.
Counsel the petitioner states the petition has been rendered infructuous. It is disposed of as such.
Special weekly list item 83.
Yes, my lord, by order dated 13/9/2012, Your Lordship, the report was asked for from the collector. What action has taken against that headmaster of the Goimunda School, High School? But she has a love relation and sexual harassment to that student. Lastly, when she attended
2012 matters, sir.
Yes.
Nothing survives now. Nothing survives now.
My lord, this school.
This is not a PIL. This is a PIL.
Yes, PIL.
Service matters, no PIL, sir.
No, service matter not it is. These persons, they are the Oilman Society, the secretary president of the Oilman Society, the villagers, the guardians committee member, and Your Lordship, the villager guardian committee member, those persons, child, they are reading in the school. Such type of headmaster, the atmosphere is polluted naturally. The student and teacher relation. Lastly, she said that he has been married to that guy.
You said with a long passage of time.
Transfer कर दी थी
That is a private. That is a private nominated.
Private recognition पाई गलानी.
Recognized, not nominated.
Recognized.
In the present petition.
Aided school.
Moreover, this petition framed as a PIL seems to be concerned with the service matter, which is usually not entertained. The petition is accordingly dismissed.
Special weekly list item 84.
My lord, pardon, my lord, is a PIL matter.
Special weekly list item 84.
Item 84. Who is an item 84?
My lord, it's a letter petition. My lord, it pertains to the year 2012, where
all right, due to long passage of time, the subsequent events have to be accounted for. Consequently, the court is not prepared to entertain the present petition in its form, leaving it open to the issue to be raised in an appropriate petition.
My lord, I be permitted to file fresh representation to the DO. My lord, DO.
Item 85.
Withdrawn, my lord, and file fresh representation to
sorry, sir.
Because
my lord, item number 85, my lord.
85.
85. I have no instruction, my lord.
No instructions dismissed. Yes.
Special weekly list item 86.
Wait, please, your lordships. My lords, in item 86, this was done by Asim Amitabh Das, my lords. I just reconstruct the file, my lords, put it next week or any date, my lord.
What's the matter about, sir? Let's see that.
This matter, I'm told.
Lord, this is a lengthy matter. Let it be adjourned to some other date. It will be hard on merit.
Counsel, the petitioner needs time to reconstruct the file list on 16th November.
My lord?
16th November. Special weekly list item 87.
All 87, it's for road safety, my lord. This case is filed for the safety of the road because it's occupied by animals, mostly by bulls and cows.
Are you appearing in person?
No.
Against Ongur municipality and Talcher municipality.
So what's the current position?
Well, no counter is filed in this case.
What is the current position, sir? 8 years have passed since you filed this petition. What is the current status of the roads in those places?
Well,
you may file a fresh petition, sir. Gather more information and file a fresh petition. You see, on the issues raised in the present petition, clearly there have been subsequent developments. The court will also like to know what the current status in the areas in question are. Permitting the petitioner to file a fresh petition in accordance with law, this petition is disposed of.
Special weekly list item 88.
88, my lord. I have no instruction.
No instructions, dismissed.
Special weekly list item 89.
None appears dismissed and non-possible.
Special weekly list item 90.
Item 90, infructuous.
Infructuous, disposed of as such.
Special weekly list item 91.
In 91, my lord, we will supply the deficit postal fee and
tell us what the matter is about.
Matter PIL matter. The opposite part number
8, Sam Deere, a power plant company, is steel and manufacturing steels, are dumping their by coal products and
You
coal
can go
products.
to the NGT, sir, for the questions raised, for the issues raised in the present petition to be open to the petitioner to
They're
approach the
dumping
National
in the
Green Tribunal.
Hirakud Dam reservoir, water reservoir.
Right.
Water pollution matter.
All right. Permitting the petitioner to avail of that remedy, the petition is disposed of.
Special weekly list item 92.
None appears. This is not possible.
Special weekly list item 93.
None appears. This is not possible.
Special weekly list item 94.
Pardon, my lord. Item number 94 permitted to withdraw.
Counsel, the petitioner seeks
Obliged,
to withdraw this petition. Dismiss this withdrawal.
Special weekly list 95.
None appears. This is not possible.
Special weekly list item 96.
None appears. This is not possible.
Special weekly list item 97.
None appears. This is not possible.
Special weekly list item 98.
None appears. This is not possible.
Passover item 32. Special weekly list item. Passover item 32.
May I please, your lords. Let's hear the petitioners file this writ application, my lords, challenging the annexure 1. This notice, my lords, for the my lords, cancellation and determination of lease granted by the ITCO, my lords, to the OP number 3, my lords. Here, what has happened, my lords? OP number 3 was granted with a lease by ITCO, my lords, to the extent of 1.5 acres of land, my lords, for my lords, setting up an industry, my lords.
Yes. Yes, sir.
And thereafter, what has happened? The OP number 3, says his project was not viable. He inducted me, and 229 decimals of land was granted to me. And I constructed a shed there, and I'm running my business since 2007. And these authorities also, he made a request to the authorities to sublet it in my favor, which was also endorsed by the OP number 2 to OP number 1 and other authorities also. While this was pending, and a circular came by the authorities, ITCO, where they have stated that subletting is also permissible but with their consent, Now, in the meantime, what matter was pending, the lease has been determined and his lease has been cancelled by the authorities, Admittedly, I'm in possession of this ITCO land. Now I'm prepared to make an application to the authorities, because there is no question of subletting now, to grant me that lease, as per their present condition, valuation, whatever they want it.
In this case, I am a petitioner for WPN 12116. The land, the land was allotted
for the petitioner.
I am for the petitioner.
For
second case is the petitioner.
Anyone for ITCO?
I am for ITCO.
So what is your response?
It's like this, Malad. Initially, the lease was granted to Ispat Casting.
All right.
Ispat Casting did not utilize the land.
Right.
What it did was it subletted to the entire land to the client of Mr. Samant Rai. Thereafter, Malad, they made an application for subletting. Subletting is not permissible for the entire land. It's only permissible for a part of the land. But there is a circular which says that mutual transfer can take place. Now, due to passage of time, they have fallen apart. So mutual transfer is not happening. Cancellation has been effected as far as the first petitioner is concerned. So if the second petitioner, who is in occupation, makes an application for allotment in his favor, it can consider him.
That is my prayer only. That is my prayer.
I am for the petitioner in the Ispat Casting, my lord. Page 18, my lord. They have cancelled they have issued cancellation letter, my lord, by the annexure 7 at page 18, my lord. On the 4 grounds, my lord, the land allotted and not utilized in industrial activities for the purpose which is allotted for manufacturing of CI pipes, fitting and hole covers and sanitary. And second, you have made unauthorized construction, additional construction without obtaining prior approval of the authority. And third one, you have all unauthorized enclosed the additional ITCO area of 0.45 and made unauthorized construction over the enclosed land. And you have misused land along the Garuda, the present petitioner, another case, my lord, to run business and Tata showroom and service, my lord. Let's you kindly say the initial the land was allotted in the year 1979, my lord. That thereafter I have taken permission from the authority, my lord. Lordship, can you see the annexure 3, my lord, at page 13. Lordship, can you, in WBC number 12116 of 12, my lord. My lord, the permission is granted by the project manager, district university center, my lord, to take up the automobile body building, repairing, service extra to additional activity in the same premises. You are also further requested to intimate this office.
Sir, are you in possession of this land?
When possession of the land, I have given subletting as per the circular, my lord. I have subletting the Garuda
No, if you sublet, then you're not using the land yourself.
Man, due to find, I have taken permission, my lord. That their activity also stopped, my lord, for last 7 years, my lord. They are not utilizing the land, my lord. They have taken as per the circular, my lord. I have also given I have taken permission from the authority. I have subletting that land, my lord. Subsequently, my lord, their activity has been stopped last 7 years, my lord.
No, who's they now?
My lord,
when you say their activity has stopped, who's they?
Who is the one? He is the third person, my lord. I have given the sublet, my lord. Now he is challenged the notice issued to present petitioner. She has challenged their same notice, my lord.
No, you have not used this land in how many years now? When was it first allotted to you, sir?
No, the land was allotted in 1979, my lord.
We are almost 50 years now. 45 years. You have not used the land for 45 years. You have not used the land.
No. I have using the land. I have the manufacturing unit is there. Subsequently,
your manufacturing unit is there.
Yes, my lord.
No, there is no such manufacturing unit. What is this new story? What manufacturing unit do you have in the land?
That manufacturing store, lordship, can see the answer 1, my lord. They have taken permission for CI pipe fitting and special.
They've taken permission, but do you have a manufacturing unit on the land?
I had manufactured the manufacturing unit. Subsequently, due to some problem, the product which are not accepted by the customers.
So you never use the land. There's a question of manufacturing unit on the land. You never use the land. You sublet the land.
Sublet in subsequently, my lord. The sublet in the year, my lord. As per in the year 2013, perhaps they have subletted the land as per the permission of the authority, my lord. So 2007, my lord. 2007, I have sublet.
In fact, his admission is there at page 12 of Annexure 2. That his business has run down and he wants to negotiate to have a Tata dealer. The Tata dealer is the other petitioner.
To
whom he has
sublet.
Not sublet. In fact, the entire possession is with the Tata dealer.
Lordship,
that is also there in my writ application at page 26. He has detail given that he has negotiated with me, Gaurav Bahan, and he has also requested the authorities to sublet it to me, Millers. Because he is not running his business.
So clearly your prayer can't be entertained because he's now fighting to get it back from you. Have you ever given him notice to vacate? Have you given him notice to vacate, sir?
Yes, I have given unauthorized is occupied, my lord. There is an agreement.
Where is your notice to him?
My lord, as per the agreement, my lord, there is for 15 years, my lord. Beyond that, he is not responding, my lord.
Where have you given notice to him, sir?
That notice not with me. I will take up. Let's give him next week. I will file. As per the agreement, he entered into my premises. Now he has challenged my ownership, my lord.
What's your prayer?
I am not challenging his ownership.
What is your prayer?
My lord?
What is your prayer?
My prayer to quash the annexure 7, my lord.
Sorry?
To quash the cancellation, my lord.
So if he succeeds in that, will you get back your land?
Yes, my lord.
Will you?
My lord?
Will you get back your land, sir, if the cancellation is revoked?
Yes, my lord. I will get back my land.
How will you get it, sir? Who's sitting on that land today?
No, he has unauthorized occupied this land.
So automatically it just vanished into thin air. Without any prayer, he will vanish. Have you sought for any prayer vis-a-vis this person to whom you have sublet?
Subsequently,
you have not made any prayer.
In fact, there were outstanding dues of about 8 lakhs, which he has annexed to his
I have paid that outstanding amount.
Just a minute. 8,82,000. He says is the outstanding. He has received a letter from EATCO And that amount is being claimed to have been paid by the other person.
Yes.
He has produced the receipt.
I have produced that receipt. I have that is annexure 10 million. By the annexure 10, Lordship, I am a regender million. I have paid that amount. That is
In
annexure
fact-
10,
in
Lordship,
fact,
I am my regender million.
In fact, the earlier, he never set up an industry. His industry was never in place. His intention was to lease it out and earn out of it. And which is not in the ITCO policy. Automobile workshop comes within the policies of ITCO, can be granted for EA. So if the second petitioner makes an application, that can be considered an EA. As far as the first petitioner is concerned, his cancellation cannot be revoked because he has no industry in the first place.
That is challenge before Lordship, my lord. That is Lordship has granted not to take any coercive action, my lord. That is subject to before this on court, my lord.
That is sufficient for this court.
Well, that is now, my lord. Lordship has-
What is his argument? What is sufficient for this court? We only said no coercive steps should be taken against you.
Lordship can just see the order, my lord. Order dated is 26/7/2012, my lord.
What does it say?
An interim measure, no coercive action shall be taken against the petitioner.
So that means that by itself is enough to allow the petition.
Well, there is a judgment of this honorable court. Of course, it's a single judgment where recalcitrant allottee is lease cannot be cancellation cannot be revoked. The lordship. Second.
All right. Say orders reserved in both matters.
Special weekly list, passover item 62.
May I please, my lord, here there is a matter that other case that 2957, which has been tagged to this matter, that may be listed, my lord, because that order was passed, my lord, without behind the back of the, my lord, board of management.
What is the matter number, sir? What matter?
The matter with regard to, my lord, industrial dispute.
What is the number, sir?
That matter, my lord, has been tagged, my lord. 2957 of 2013. 2013. 2957, that is a disposal of case, but we have filed an intervention application also for recalling the order. That was heard by this
That's already there. I think the 2957 is already there.
Yes, that is already there, but that is since it has not been, the name of the advocate doesn't appear, the petitioner may not.
With due respect to my senior lordship, your lordship has a glance to what they have challenged your lordship. Your lordship has a glance to page number 58, your lordship. The order of reference made by the appropriate government regarding dismissal of a workman, your lordship. That has been stayed, your lordship.
Well, here what has happened, my lord, the person who is not an employer, he has been made a party, and an order was taken by this honorable court, where this honorable court has disposed of that order by that in that writ application, my lord. That
No,
they will
in 2957, some application has been filed.
Yes, my lord.
What is the number of that application?
My lord, I have annexed those applications in this writ application also, my lord. Those two applications I have also annexed there, my lord.
There is no application in 2957.
Yes, my lord. That is application is on a mistress number 3608
of 2013.
Yes, and 3609.
We will show separately IA number 3608 of 2013 and 2957 of 2013 in the cause list, indicating name of cons. List on 22nd November.
Interim order to continue in this.
The reference has been stayed, and in the meantime, the
No,
claim
I
application and the WS has already been filed, Your Lordship.
All right.
Weekly list item 1. Weekly list item 1.
This PL is pertaining to the release of vehicles from the police stations.
This police department has to file an
Yes,
affidavit. What happened?
we have received from some police stations. So
Mr. Mohanty says that some
I'll take a
information has been received from
comprehensive-
some of the police stations, which he will consolidate and file as an affidavit positively before the next date. List on 19 September. The second matter also same date, 19 September. That both matters are there, I think. Anyway, call out item 2.
Weekly list item 2.
Defects have not been removed. This is after notice.
The representation is there.
Some representations have been given.
11/4/2022.
But there's no proof of
There's
postal.
no proof. Well, there is a, my lords may see page 13.
1-3.
Page 1-3.
Received. All right. The petitioner's representations dated 11th April 2022 will be examined by the Tahsildar Rasagobindpur.
Please, my lords.
And after issuing notice to the petitioners and giving them a hearing. And opposite party number 7 and giving them a hearing. And after receiving inputs from the opposite parties 5 and 6, the detailed reasoned order shall be passed not later than 30th September 2022. A copy of the order shall be made available not later than 7th October 2022. The court clarifies it is not expressed in the
Weekly list item 3.
Item 3, may I please, Your Lordship? Your Lordship, this is the PIL, wherein the petitioners have challenged the action of the opposite party authorities who have already completed the construction of paver block road from Irrigation Road to Kiran Barik House.
Again, representation. You
Yes,
have a
Your Lordship.
postal proof of this sending this representation. You have any proof of this representation having been sent
Your
to the
Lordship,
collector?
I have annexed the representation.
Sorry?
I have annexed the representation, Lordship.
Do you have proof that the representation was delivered to the collector?
No.
Make a
Lordship, I
fresh
have sent it
representation.
by post, but I have not annexed the postal receipts.
Do you have the postal receipt with you?
I'll obtain instructions.
Okay, at the request of counsel, the petitioner wants time to produce the postal receipts. List on 23rd August.
Obliged.
Weekly list item 4.
May I please, Your Lordship, on behalf of Mr. Bora, I'm offering. The petitioner has filed a PIL challenging the action of the opposite party's authorities to set up a bus stand near BSc High School.
You have a representation.
Sorry, Lordship.
You say petitioner's representations be considered by the secretary. Department of Transport and Communication. And after hearing the petitioners on dates to be communicated to them at least 10 days in advance, a reasoned order should be passed not later than 17th October 2022 and be made available to the petitioners not within a week thereafter. The petition is disposed of in the outcomes.
Weekly list item 5.
Obliged.
Yes, Mr.
May I please, Your Lordship? Case 2 is the question of law. Whether the Honorable Tribunal is justified in partially allowing the appeal when it came to a finding that books of account maintained by the dealer did not give correct picture of its activities. Whether the Honorable Tribunal is justified in deleting the enhancement for all the impugned years basing on fresh evidence under Rule 61.
We'll
of the
pass a detailed order, sir. We're not going to interfere in these kind of matters.
In fact, if your lordship would kindly turn to page
They're all
9.
purely factual, sir. We'll pass a detailed order. Dismissed. Yes.
Weekly list item 6.
My lord, in this case, state was to file the response to the SI pursuant to your lordship's order dated 16/5.
Who's appearing for the state? Who's appearing for the state?
Let's Mr. Debakant Mohanty was appearing. Let's adjourn the matter.
There's an additional affidavit, sir. An additional affidavit has been handed over today, copy of which we given to the petitioner today itself. List on 21st September.
Let a copy of the
Weekly list item 7.
In this case, petitioner challenged the order of the learned tribunal, wherein the learned tribunal has been free to dispose of batch of cases. Your lordship in 7/2022 directed the AGA to obtain instruction for the status of the other writs challenging by the other applicants. Kind of have glanced already 7/22.
Yes, sir. What's your instruction?
Well, it's, with regard to the other orders, Millards, instructions haven't been received. The batch of matters, but Millards, the last order, Millards, the SLP that has been mentioned, Millards 12485, Millards, that pertains to some other matter. In fact, I checked up the Supreme Court registry. Therefore, Millards, with regard to instructions, with regard to the other matters, my lords may give me some time.
At the request of counsel, the state who needs more time for instructions. 28 September. 28.
Weekly list item 8.
My lord, in item 8, it is already complied and compliance affidavit has been filed. That benefit of IS effect scale up has already been extended to the petition. That benefit of IS effect scale up has already been extended to the petition.
My lord, I do not have a copy of their reply. Let me see and examine whether
I am just now I am talking.
Let it come some other day, my lord. I will take instruction what is happened to that.
It's a 2010 matter, sir. An affidavit has been filed stating that the benefit has already been extended to the petitioner. Copy of the affidavit has been supplied to counsel the petitioner. The petition is accordingly disposed of. It will be open to the petitioner to apply for directions if compliance is not as claimed in the affidavit.
Weekly list item 9.
May it please, your lordship. In item 9, your lordship, the last date in this matter, state has to take some instructions.
Let's come any other day, my lord. Mohanty is not there.
All right. At the request of Mr. Mudali. List on 9th November.
Weekly list item 10.
None appears to is not possible.
Weekly list item 11.
Due to sad demise of the previous council lordship, today filing the fresh Vakalatnama and the senior memo lordship. 2 weeks time may be allowed lordship. Today morning we have received the brief lordship.
Counsel, the petitioner says that he's just filed Vakalatnama for the petitioner. List on 19th October.
Weekly list item 12.
None appears to is not possible.
Weekly list item 13.
Sir, in this matter, petitioner 6 kindly permitted to be withdrawn and liberty be granted to file a better application.
All right. Counsel, the petitioner seeks leave to withdraw this petition with liberty to file a better application.
Weekly list item 14.
May I please? Item number 14 and item number 23 both are interconnected. In item number 14, I today filed the rejoinder, my lord.
All right. Rejoinder has been filed today. Interim order to continue. List on 16th November.
Well, my appearance is well noted.
All right.
Weekly list item 15.
14 and 23
The matter related to disposal of drugs. In the cases, in 7 cases, was about 8 kgs, 707 grams of brown sugar has been disposed of.
File an affidavit, sir, or you have a report. Mr. Katkia has submitted a report on the disposal of drugs. A detailed further updated status report we filed for the next date, same date as that other matter. The same date as that.
The noting shows 5 cases, so it is 7 cases.
As item 1. Same date as item 1. Right.
Weekly list item 16.
The item 16. Is the road is
Please dismiss.
Weekly list item 17.
May I please, Your Lordship. Your Lordship, this is regarding notice of notice under 271C, Your Lordship.
1 minute. 16 is what? 1 minute. We have to file some spot map or something in 16.
Yes, my lords. We have filed a spot map. The spot map shows that there is in fact a road adjoining the Anganwadi center, which seems to be the grievance of the petitioner. My lords may see my memo. I filed the memo dated 7th of February 2020.
All right. You say none appeals to the petitioner in the interest of justice. List on 11th October.
Weekly list item 17.
In this matter, Your Lordship, I have challenged Annexure 3 notice regarding penalty proceeding, Your Lordships. But in the counter, Mr. Chimanka has already admitted that I have paid entire tax amount. Because of the implementation of faceless assessment scheme, they have issued the notice.
All right. Yes, Mr. Chimanka. What happened to?
He's muted.
Notice is already gone.
Yes. He has already filed counter saying admitting the facts.
But we have not received any counter. Where is your counter, sir?
Yeah, I filed counter on.
The counter affidavit stated to have been filed by the revenue we brought on record. Interim order to continue. List on 20th September.
Oh, blessed.
Weekly list item 18.
Your Lordship was pleased to issue notice to IDCO to file its counter. They have not filed it, my Lord.
All right. Counter be filed within 4 weeks. Rejoined for the next date. List on 19th October. Is there any interim order?
No, Your Lordship. No.
All right.
Weekly list item 19.
We'll have it on some other day, sir.
Yes.
Interim
But they
orders
have
to continue. List on 26th October.
May I pray, my lords, one thing? Let them produce the assessment records.
All right. The assessment
And
record
also,
we produce.
Sorry, Lordship, you have a challenge
only notice, my lord. Why assessment record is required, my lord?
assessment record is very much
Notice has
necessary.
been challenged.
Anyway, we have to hear it.
Yes. Lordship may also counter affidavit.
Counter have already been filed.
Why I am telling, my lords? Why I am telling you?
No time, sir. We have to have a reference now. All right.
Weekly list item 20.
Yes.
Same, my lord. Same here.
Same order.
Yes.
Right.
Weekly list item 21.
21 become infructuous, my lord.
Counsel, the petitioner says the petition has been rendered infructuous. It is disposed of as such.
Weekly list item 22.
22, no counter affidavit has been filed.
1 week time to file counter.
All right. Reply within 4 weeks. Rejoined for the next date. Interim order to continue 26th October.
Yes.
26 October.
Yes.
Weekly list item 23.
Interim order to continue.
Item 23, my lord. I have already filed the rejoinder copy. Today I served the copy.
All right. List on 27th October. Interim order to continue. Yeah.
Weekly list item 24.
24 pray for time to file a rejoinder, my lord.
Rejoined for the next date. List on 3rd November.
Plus, I am filing written. Plus, I am filing written argument. The matter was argued on 14 plus.
All right. All right. 25.
Plus, I filed written argument. So that matter was argued on.
All right. All right.